Any, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, or within the Commonwealth. Draw near, give your attendance, and you shall be heard. That's in the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice John Englander. To my left, Justice Marguerite Grant will be your panel for the 5 cases today. Our third case, Afrasiabi versus Harvard University, is off the list. We'll hear 3 arguments. We expect to hear 3 arguments and then take a brief mid-morning break and then come back for the other 2. If you've been to the Appeals Court before, you know that there's 15 minutes per side. There is no rebuttal. When the green light turns yellow, you've got, I think, 90 seconds left, and then when the yellow turns red, you're done. We'll let you finish your sentence for sure. We have read your briefs. We know the facts. We know the issues. So I would urge all of you to get right to the heart of your argument. With that, I'll call the first case, partially impounded, 23P931, Edward Pierce v. Victor CORREIA.
Good morning, and may it please the Court, Mary Murray for the respondent, Victor CORREIA, referred to as the Commonwealth at the court below and in our papers here. The Court has posed the question of whether the Commonwealth is entitled to appeal in its order that issued on Tuesday of this week. The Commonwealth's response to that is yes. Appealing whether the petition for writ of habeas corpus is an appropriate available avenue here is within the Commonwealth's ability. And I invite the Court's attention to 2 cases. First is Newton, 357 Mass. 346, 1970. And I should start by saying...
Sorry, what's the rest of that? 357 Mass.
346, 1970. Newton was an SDP who filed a petition for writ of habeas corpus claiming he wasn't receiving adequate treatment. The judge granted the petition, and the case went to the Supreme Judicial Court on the Commonwealth's Bill of Exceptions, which suggests 2 things, that the SJC decided it, and reversed the order of the lower court judge, that the order of the judge was improvidently granted, and the exceptions are sustained and the petition must be dismissed, which suggests 2 things, that an appellate court has the power to review at the Commonwealth's request, and that if there is a right to object, it can be waived. Now, to be sure, there was no discussion of whether there had been an objection in the Newton case itself. And the Commonwealth does request the Court's permission to file a written response to Mr. Keneally's, Mr. Pierce's motion, filed on his behalf by Mr. Keneally, motion that came in after the close of business Wednesday night. And we do request 2 weeks to be able to file a response.
And so there was no discussion in the Newton case of whether this was a proper appeal from a grant of habeas relief?
Well, I take it because they decided it, the court concluded that it had jurisdiction to decide it, and I have not known any appellate court, including this one, to be bashful if it thinks it lacks jurisdiction, to raise the question sua sponte.
But there was no discussion of it.
But there was no discussion, to be fair.
But wouldn't the SJC, couldn't they have heard it under 211.3? In other words, if there was no avenue of relief for the Commonwealth to appeal from the improper grant of habeas, then the SJC could have considered it under 211.3.
Absolutely, and that's one of the cases I want to talk about in just a moment. But in Newton, they don't say specifically that that's what they have done. So I bring this to the Court's attention. Obviously, this is a recently raised issue, and I want to fully vet it for the Court as a matter of candor to the tribunal, but in preliminary review and research, and I'm well familiar with the Newton case because it does involve a sexually dangerous person matter, which is one of my areas of practice. But because this is an issue of concern to the Court, the Commonwealth also respectfully suggests that the question be referred to the Supreme Judicial Court pursuant to Mass Rule of Appellate Procedure 27.1e, that if a majority of justices of the appeals court or of the panel considering a case certify that the public interest or the interests of justice make further appellate review advisable, then that certificate can be transmitted by the clerk of this court to the clerk of the SJC. You're all well familiar with that process, I am confident.
Well, I like the way you framed the question. because I found that to be an interesting way that I'd been thinking of it as well, which is the question that you framed is whether habeas is the proper avenue.
That's right.
In other words, the fact that it's labeled a petition for habeas corpus or that the court below treated it as a petition for habeas corpus doesn't necessarily mean it's a petition for habeas corpus. It might be something entirely different.
That's right. And if we allow people to label things as a petition for a habeas corpus, that would be an irresistible temptation to trial judges to label everything habeas and make it entirely unreviewable by the court whenever the Commonwealth does not prevail. But I did want to draw to the court's attention the Pires, and I hope I'm saying the name right, P-I-R-E-S case in 2002, where the sheriff of Suffolk County brought to the court's attention by means of a 211-3 petition whether the question of whether habeas is an appropriate mechanism with respect to a bail issue, a bail revocation issue. So it's clear the Commonwealth can seek, the government can seek review of the question.
The Commonwealth didn't say below, hey, habeas is the wrong avenue, did it?
Yes, the Commonwealth most certainly did, in the opposition to the habeas, saying habeas doesn't lie here because he had an avenue of direct review.
Yeah, right.
Over and over and over again.
Okay, got it.
Forcefully, repeatedly, persistently, and has said it here at this court. So we absolutely did raise it below in the opposition and in the reply, and specifically argued there's no constitutional impediment. The constitutional issue of requirement of expert opinion rooted in due process rights was met. The district attorney had expert opinion that the judge fully credited.
Okay, so now you've turned to the merits, right?
But that's why
So
we
can
argued.
I just ask you on that score? All right. It seems to me that there are two constitutional arguments that are floating around. One constitutional argument is along the lines of that the evidence presented was inadequate because you didn't have a qualified examiner. Somehow the suggestion, it seems to me, is that due process required a qualified examiner. Let's leave that argument aside. There's another argument, which is you didn't meet your burden of proof. You didn't prove a required element in accordance with the opinion in Johnstone, Judge Cowan's opinion in Johnstone. What do you say to that?
I say two things. The constitutional requirement for expert opinion was decided long before Johnstone, and it was decided certainly recently in Bruno, 2 years before the trial at issue in this case. And the court said expert opinion is required because these are matters beyond the understanding of ordinary lay persons to prove that somebody has a condition that makes the person likely to reoffend. So you need expert opinion, essentially as the DA to file the petition, and then to get to the trial for finding of probable cause, and then, of course, it has to be credited beyond a reasonable doubt.
But why is that important?
Here.
I saw that in your briefs. I don't understand why that's important. That doesn't really address the argument, which I think is being made. They're not teased out very well, but the argument that says it is a constitutional requirement, at least in a criminal case, that you have to prove each and every element that the government is attempting to prove in a criminal case, each and every element of the crime, right?
Sure.
And Johnstone says one element, they don't say it this way, Johnstone says you have to have a qualified examiner.
Johnstone was decided.
Otherwise, quote, you cannot meet your burden of proof, unquote.
Johnstone was decided as a matter purely of statutory construction, and we know that from the SJC's decision in 2010 in McIntyre.
I accept that.
That says the source of the expert opinion, but the constitutional issue, having expert opinion, was decided for a due process standpoint. Johnstone is not a constitutional holding. It is saying that as a matter of statutory construction, these QEs, who, by the way, are a creature of statutory...
I get it. I get what you're saying. I get what you're saying, but it's not addressing the second constitutional argument that I think is being made. That is being made as it's the Virginia case, the U.S. Supreme Court's case, Jackson against Virginia.
I think I can address it I don't mean to interrupt you, Justice Sachs.
No, I was just going to say the question is if the evidence wasn't sufficient, usually the result is judgment for the defendant.
And the evidence...
Because of double jeopardy. Now, this is a civil case.
This is a civil case, but also in McIntyre, the SJC rejected the claim that the underlying commitment order was void from inception because it violated the Constitution. So McIntyre actually disposes of that issue. They said, we decided it as a matter of statutory construction. So because McIntyre was on direct appeal, we are reversing it. McIntyre, of course, was held on subsequent findings of sexual dangerousness, so he didn't get released. But when you look at McIntyre, they did not say, the court rejected the argument that there was a due process violation because of the absence of a qualified examiner opinion. The legislature created the qualified examiners in 1985, and the legislature could abolish them without impairing the integrity of the statute, because it could just say, each side pick your own experts and go forth. And go. And that would not impair due process. This statute was in existence for decades before the QEs were created in 1985. And this court, actually the SJC and the United States Supreme Court, upheld the statute as meeting constitutional requirements. So the QEs, who are nowhere mentioned in any state or federal constitution, are not constitutionally required, but the SJC did decide as a matter of statutory construction that given their role, that the Commonwealth has to have one of their opinions in order to proceed, and of course that's how we proceed today.
Is there a difference? Let's assume with me for a moment that that the SJC has said you need a qualified examiner to meet your burden of proof, and that no qualified examiner was present in 2002 at this trial supporting the Commonwealth. Just assume that. Is there a difference between that failure and the kinds of failures of proof that have been held in the criminal cases to be a substantial risk of a miscarriage of justice? Is there a way to distinguish those?
There is no substantial risk of miscarriage of justice here because the Commonwealth offered expert opinion, which the judge credited beyond a reasonable doubt. There's no for example, lack of a conviction, which is required. There's no want of expert evidence, which is required as a matter of constitutional right. So Mr. Pierce could have challenged this on direct appeal and made his arguments, and the court would have done what it would have done. But there's no constitutional impediment to his continued commitment. And he took himself out of the review as of right by fleeing the Commonwealth, living as a fugitive for years out of state, and then when he was brought back into the Commonwealth, he filed a late notice of appeal, which...
That's a different argument. That argument is, even assuming that there was a constitutional violation here, he had to address that on direct appeal. He failed to do so.
Right.
And there's no basis for relief.
That's right. And there's less of a concern in these cases because he has the recurring ability to challenge his current status. And as the record shows, he has withdrawn all of the petitions, and in 2017, when he withdrew a petition that was getting ready to go to trial, he said, in his own affidavit, signed by him, and in the record in this case, said, if I go forward, I'm not likely to succeed. So that was a concession that he remained sexually dangerous in the Commonwealth's view. And he was represented throughout all of these proceedings by attorneys over and over and over again.
How many times did he start the process?
I believe 5 times. He's had 5 Section 9 petitions. He's withdrawn them all, except for the one that's still pending. It was scheduled for trial in 2023, and I believe I did have a Scrivener's error, my own fault, and said 2022 at one point in the brief. So I do apologize for that typo. But it was in 2023, and he asked not to have the QEs evaluate him. In all the petitions except for one, he got rid of the petition before the QEs saw him. In 2012, QEs saw him and opined that he was sexually dangerous. And I think in all the other instances, he elected not to be reviewed by the QEs and withdrew his petitions, except for the current pending one. So
how can he elect not to be reviewed by the QEs? Doesn't that have to happen?
It does, except he withdrew it before the qualified examiner saw him. So in the Section 9 process, the court issues a trial date, and there's a standing order about when the evaluations have to be completed. Currently, the standing order requires 6 weeks in advance of the trial. So the QEs would be setting up appointments and going to meet with the individual 2 or 3 months in advance. All the lawyers know this because it's a standing order. And so his lawyers apparently, and he decided to pull the petitions before the QEs would be scheduling to see him. Frankly, that was, if he doesn't want to go forward, I think it's a good idea so that time and energy is not, and money are not spent on those things if the individual doesn't want to go forward. But in any event, he's had multiple opportunities and recurring opportunities, and all of the issues about his...
Pulled it 5 times. When was the first time he pulled it?
He had a 2007 petition that I believe was scheduled for trial in
When did he go to jail? When did he go to jail for the crime?
So he was brought back into the Commonwealth in 2005. He was put into the treatment center because of the existing 2002 order. The criminal cases were proceeding, and he was convicted of the rapes. He was convicted of other charges as well, but of the rapes in 2008 and got a criminal sentence. And when you get a criminal sentence, when you're an SDP, unless there's an unusual order for it to run from and after all confinement, it runs concurrently. So he served that criminal sentence while sexually dangerous at the treatment center.
He started it serving in 2008.
Right.
So he pulled his first Section 9 before that. Did he pull other Section 9s while he was incarcerated for the crime?
Right. So actually, the first Section 9, I think he withdrew it shortly before the trial date, which I believe was 2010. Had he been found not sexually dangerous, he would have been remanded to a general prison to serve the rest of his sentence, his criminal sentence, because the adjudication of not sexually dangerous would not affect the sentence. And I see that I have gone over my time.
I have one more question, and perhaps Justice Grant does. If substantial risk of miscarriage of justice review is available on direct appeal, as in the RB case, then why would it not be available in the habeas context?
That's when a case is properly before the court. And he voluntarily forfeited his rights twice to have his case put before the court. First, by fleeing, he forfeited the direct appeal as of right. And second, when he came back into the Commonwealth, he filed a notice of appeal, essentially asking the court to exercise its discretion to let him notice the appeal late, as he was entitled to do. Then, and then the Commonwealth was entitled to oppose it.
Right. So frequently, a substantial risk review is undertaken on a motion for new trial or an appeal in a criminal context, on a motion for new trial or on an appeal from a denial of a motion for new trial. So here, this being civil, he could have moved for a new trial, I suppose. I think the time period is 10 days, short, but in theory, he could have moved for a new trial and raised an issue that he didn't raise prior to judgment. And then if that were denied, he could appeal and obtain substantial risk review?
Yeah. Yes, except it's important to point out that he did raise the absence of qualified examiner
understood.
Opinions by motion of a summary judgment.
Just trying to get the procedure state. We know your position that, that he raised it.
He raised it. He knew about it.
Wait, but why is that important? I might be missing something. Is it because since he raised it below, he could only raise it on direct appeal?
No, that's not what I'm saying. People raise waived claims, and under the case of RB, the SJC has said that's a substantial risk for a waived claim in an SDP case would apply. But it's important because one of the things that the judge below seemed to be concerned about is that Johnstone hadn't been decided and was trying to liken this to a constitutional issue that you couldn't have known about. But of course, they did know about because they raised it.
Got it.
Yeah. Okay. All right. Thank you very much for your argument.
And Marquardt hadn't been decided either.
And Marquardt has been decided shortly after the QE reports were done, shortly before the trial, which is why Judge Healy could entertain the victims. And the Commonwealth does renew its request to submit a response within 2 weeks.
We'll issue an order if we want that.
Thank you.
Okay. Thank you. All right. Mr. Keneally, and since the Commonwealth had 3 extra minutes, I'm going to either ask our assistant clerk to set the timer at 18 minutes, or else I'll just we'll just keep track of the 3 minutes at the end, whichever is easier.
I appreciate that, Your Honor. Justice Sachs, may it please the Court, Your Honors, my name is Joseph Keneally for Edward Pierce. Before I forget, Your Honors, I just want to jump in on that substantial risk claim that you made, because in the course of argument, I might lose track of it. The Commonwealth's position is that substantial risk of miscarriage of justice claims can only be raised when properly before the court. I would suggest that that's a little bit circular in his argument, because a substantial risk of a miscarriage of justice standard is only applied in circumstances when the claim has been waived and is thus not properly before the court.
But it's a standard of review.
It is a
It's not a freestanding claim.
It's not a claim, no.
So the claim here was habeas corpus. He
Right.
was unlawfully confined. And one of the rules in the habeas context is that one cannot raise an issue that could have been raised at trial.
Yes, that's true. Although, I mean, if you look at the case,
So there may be substantial risk review in the criminal context, but in the in a direct appeal or appeal from a ruling on a motion for a new trial, but how does that apply in the habeas context?
As Your Honor said, this is a circumstance where Mr. Pierce could have, in the alternative, filed a motion for new trial to address this issue as well, and that would have applied. And ultimately, I think
If he'd filed a motion for a new trial, we wouldn't have any issue with respect to whether this appeal is proper, would we?
Pardon me?
If he'd filed it as a motion for new trial,
Yes.
we wouldn't have any issue as to whether this appeal is proper, would we?
No, we wouldn't. But, you know,
Okay.
the through line here is a motion for a new trial, by definition, is asking for a new trial. And Mr. Pierce was not asking for a new trial. He was claiming that he was improperly being detained as a result of a violation of the law, which is the functional definition of a habeas petition.
But
And
isn't that what Judge Chin decided in the motion, in denying the motion for summary judgment? And as far as I can see, Judge Callahan, in his order, doesn't mention Judge Chin's ruling at all.
the summary judgment ruling?
Right.
No, I don't. You're right. He doesn't mention that ruling at all. However, you know, he did state that the habeas petition issue does not become available to Mr. Pierce until after he completed his sentence. There's no reason for him to file a habeas petition until after that point. So at that point, he was able to move forward with it and make the claim. You know, the Commonwealth's position here, I don't think that they forcibly argue that this judgment, this civil commitment order, violates Johnstone. They relegate their argument to essentially the last 6 paragraphs of their brief. They don't say that this is, you know, consistent with Johnstone. And I think there are a couple of reasons for it.
So, all right. I mean, we understand your position about how qualified examiner testimony that he was sexually dangerous was required at trial.
Yes.
I want to make sure I understand the constitutional basis, if any, of that claim. Do you say that procedural due process requires that there be an opinion from a qualified examiner at trial that the respondent is sexually dangerous?
Yes, I think I do, Your Honor.
Okay. So if a judgment is rendered without procedural due process in the civil context, then under Rule 60b-4, that judgment is void, and it can be vacated at any time.
Okay.
Could you have moved for relief under 60b-4, assuming that to raise your claim that the judgment was void because he was denied procedural due process?
Absolutely. I mean, it could have been. This issue could have been addressed a long time ago.
Well, no, he could do. There's no time limit under 60b-4.
No, well, I'm saying that once Johnstone's decision came down, it became perfectly clear that there's a problem with the civil commitment order. A lot could have been done to address this. I would suggest that.
Well, I'm addressing your point that it can't possibly be that he can if he gets committed on insufficient or inadequate evidence, he has no way to raise it. And I'm suggesting that he does have a way that would have survived at the time that he filed this habeas petition, which is to file a 60b-4 motion.
Well, I suppose technically the rules of civil procedure, actually the law states that the rules of civil procedure do not strictly apply to STP proceedings.
Which law says that?
I don't have it off the top of my head. I can get it to Your Honor. But I think that there's a provision that says that the rules of civil procedure do not apply to, I know that's the law. I don't have it off the top of my head, and I apologize for that. However, I would submit that, the issue as to whether what could have been done to address this Johnstone error is, I would suggest, not as important as the fact that the Johnstone error took place here, okay? Because
Okay, well, there has to be some proper way to address it, and what you're relying on and what the judge is relying on is the idea that the de Joinville theory, that the constitutional theory wasn't sufficiently developed at the time of trial for him to raise it,
yes,
right?
Yes.
So what is the constitutional development that occurred after trial
okay.
that made this a viable claim when it wasn't before?
So prior to Johnstone,
I'm not asking what is the constitutional significance. I'm asking what is the development in constitutional law, and I assume it's procedural due process law,
yes, I would.
that made this a viable theory when it wasn't at trial.
Well, I mean, in terms of a constitutional issue, it wasn't made a viable theory until the Johnstone decision. Because the prior statute, the prior civil commitment statute.
But does Johnstone have any constitutional analysis in it, or does it just say procedural due process applies?
It definitely has constitutional. I mean, what they say.
It is the principle of procedural due process that wasn't sufficiently developed until Johnstone. I don't see Johnstone as making any milestone constitutional declaration.
Well, I mean,
it's not like Miranda or
if this was strictly a issue of statutory interpretation, as the Commonwealth has alleged here, then the court could have looked at the civil commitment statute and then just applied principles of statutory construction. They could look at the statute and say there's no requirement in here that.
But they've
They
said
could have,
again
but they
and
didn't.
again, we find it implicit in the statute. And I want to ask you about Chapman, I believe it's Chapman, which says, not only, they repeat, in Johnstone, we held that Chapter 123A implicitly provides that a person can't be committed or denied release unless a qualified examiner opines. But Johnstone then says, Chapman says, stare decisis counsels against overruling Johnstone, as the Commonwealth asks, in part because we issued our Johnstone ruling 10 years ago, and the legislature had every opportunity to overrule it.
Yes.
They've amended Chapter 123A twice since the Johnstone decision, yet they haven't touched it. So since they could overrule it, and they haven't, why should we overrule it? They've sort of implicitly ratified it, I think is what the SJC was saying. If Johnstone was a constitutional decision, then why was the SJC saying the legislature could have overruled it?
Well, I think that if the legislature could have rewritten it in such a way as to indicate, to reconfigure the role of the qualified examiners in the way that was inconsistent with, they could have restructured the entire civil commitment statute if they wanted to do that to avoid that sort of thing. I don't think that this is a situation where the legislature would have been inclined to do that simply because.
Oh, but doesn't that concede away your procedural due process argument? If the legislature has the ability to put somebody to civilly commit someone as sexually dangerous without a qualified examiner, isn't that the end of that constitutional argument?
This is a circumstance here, I think, where the court has determined that there are, and Chapman, the court determined that there are significant constitutional problems with the notion of not requiring qualified examiners to, at least one qualified examiner, to conclude that an individual is sexually dangerous for the case to go to trial.
Is that what they say in Chapman?
Yes, they say that it raises
Significant constitutional problems?
They're
Or just, given the structure, you need a qualified examiner? Given the structure of our statute, that's the way I read Johnstone. Given the structure of our statute, you need a qualified examiner, but here we had an expert. In this case, there was an expert.
But, you know,
Why isn't that enough under either the federal or the state constitution? Why isn't it enough that there was expert testimony that satisfied the various elements of showing that someone is sexually dangerous?
because the Johnstone decision says that it's not, as a principle, matter of due
Did
process.
QE Murphy's QE report set forth probable cause that Pierce was SDP?
Yes.
So why?
Sorry. The qualified examiner Murphy, when he drafted his qualified examiner's report, he indicated that if in fact Mr. Pierce,
If these allegations are true,
could have considered these allegations.
but he thought he couldn't as a result
Thought
of
he couldn't.
a mistake, and then Marquardt came down.
Well, I mean, I don't even think it's really a matter of Marquardt, because if you look at DYS versus the juvenile, the case from 1986, that case says that an expert can consider any evidence that could be
Right.
admitted at trial.
So what standard of proof did QE Murphy have to meet? Probable cause or beyond a reasonable doubt?
Well, no, I mean, generally, when qualified examiners submit the reports, they don't apply a legal standard, it's a scientific standard. They basically come to a conclusion as to whether or not the individual is sexually dangerous, because
And it's a black and white thing? If they say, even if they say, if I could consider this other evidence, I would find him sexually
Well,
dangerous?
but that's not what Dr. Murphy stated. Dr. Murphy stated if he could consider this other evidence, he would have indicated that that would recognize that Mr. Pierce had trouble understanding the nature of his offending and the basis of his offending, and that would lead to an increased risk. Dr. Murphy never said it would lead to an actual risk, that would make him likely to reoffend. And he certainly didn't say, if I could consider this other information, I would have found him sexually dangerous.
What if DOC had called Murphy at the trial before Judge Healy
They could have.
and said, what's your opinion now?
Well, you know, the thing is, Your Honor, the DOC could have done a lot of things here. The DOC could have, the trial took place a year after these qualified examiner decisions. Almost all the time in these circumstances, the qualified examiners are asked to update their QE reports. They could have contacted him any time to say, update the QE reports. In fact, Attorney Holmes, who was the prosecutor in this case, had been doing it routinely, asking for updated reports. They could have asked for updated reports if they wanted to. They didn't do it. They decided to go forward with trial. If what they could have done, knowing that they had these allegations of this uncharged conduct, they could have dropped the SDP petition altogether. And what they could have done at that point is file an indictment against him for the particular crimes that he was clearly alleged to have committed, had him convicted, and then when he was being released, filed an SDP against him. Also, after Johnstone was decided, the DOC had 13 years to review the people who might have been found SDP in violation of Johnstone, 13 years to look at who was there and say, essentially, these people, these commitments are a violation of Johnstone. We can, in Pierce's case, remand him to the DOC where he was serving a criminal sentence, and then in 2023, when he had the opportunity to be released, filed an SDP against him. They had 20 years to do something about it.
Can I just make sure I understand? Once he's out, they can't file an SDP petition?
No, but he would never have been released at that point.
No, I just want to understand, as a general matter, under 123A, someone who's been released from a criminal sentence or discharged from a sexually dangerous person's commitment.
Yes,
once they're out, they can't go back in, or they can't be compelled to go back in unless they commit another sex offense.
Exactly. So the government basically.
Why is that?
Statute.
That's just what the statute says. And there's case law that says once.
I'm sorry that I'm slow, but the statute says, because
Statute
this
says
is an
you
issue
can
that I...
only file a petition against a prisoner. And if you're not a prisoner,
Oh, I see.
then you're not, then they can't file a petition against you. It's limited to prisoners. There's a lot of language out there that says, is a person not a prisoner or is a person a prisoner based on,
Thank you.
So if we were to rule, hypothetically, yeah, the proof didn't comply with Johnstone, but he's not entitled to release. He should get a new trial to see whether the Commonwealth can meet its burden now that it knows what Johnstone is. Is there a mechanism to do that? I mean, isn't that often the result on substantial risk review in the criminal context, that the judgment's vacated and it's
No, I mean,
remanded for a new trial?
I think Johnstone and Chapman both say that and McIntyre and Green, they all say that if there's not at least one qualified examiner, then the Commonwealth has not brought sufficient proof to meet its burden, and the case does not go to trial. This 2002 case pursuant to Johnstone was not supposed to go to trial at all. There wasn't supposed to be any decisions by a judge. There wasn't supposed to be a direct appeal. There wasn't supposed to be anything. Pursuant to Johnstone, it should have been dismissed. And Chapman spoke to this exact issue where we have a situation where the qualified examiners may have got something wrong. And they said in Chapman that if we have two qualified examiners who are demonstrably incorrect in their decision, and they still find, and as a result of those errors, find someone to be not dangerous, we got to let them go. They said, I'm quoting here from...
Can't we take into consideration that the law was developing at the time in 2002? I mean, can't we take... Johnstone didn't exist. It was not an unusual practice for someone to go, as I understand it, it happened more than once. Somebody went to trial without any qualified examiner. Qualified examiners didn't know the right rules with respect to what they could consider.
Well,
In this case, they did not understand the right rules. Those rules were written later, as I understand it.
no, I would respectfully disagree. The rules were not written later. In 1986, the DUIS case said that a qualified examiner can consider any evidence that could be admissible at trial. In this case, the child victims of uncharged conduct testified at trial. They could have considered that. Marquardt didn't break any new ground here. DYS had that established. Marquardt more or less reminded it that would apply to qualified examiners in this case. So that would, I know it's...
Wait, you say that this is a 1986 case that said that?
DYS versus a juvenile?
Yeah, but they rewrote the statute in 1999.
Yeah, but this is a principle of how experts are able to evaluate information.
And the QEs are supposed to know that. A juvenile court case.
Either the QEs or you know, the government who is going to put them on trial as witnesses for their evidence. I mean, if I have a potential witness who's got the law wrong, I might want to let them know that so they can file an updated qualified examiner report.
You know, the way to test that would have been to take a direct appeal and make the argument that was made below. But that didn't happen.
No.
And here we are 22 years later because your client fled the jurisdiction.
Okay, well, first of all, he had, one doesn't waive one's right to appeal by fleeing the jurisdiction. The law does not say that. It's at the discretion of the...
Sure, if you've got an appeal pending, then you may not waive it by fleeing if you come back. But he didn't timely appeal.
Well, I mean, here's the thing. So we have a situation here where we know that there's a Johnstone error here. We know that this improper civil commitment order is the only thing that had been keeping Mr. Pierce incarcerated at the time that he was...
Well, but again, you see, that word improper is a loaded term because it has to be a basis for extraordinary relief. And just a failure of process is not enough. A failure to follow the statute. I don't think enough, is it, on habeas? I don't know exactly what the standard is.
Well,
But you say, oh, he's improperly held. Well, we've got lots of cases that say, look, if it's something that could have been raised on direct appeal, it's not a habeas case. You've got to at least get to the Constitution.
I would suggest that that he was not being held. He's being held absent sufficient evidence to issue a commitment order, which is Jackson versus Virginia, which is what you raised.
Well, that's the question I asked that raises the question I asked your opponent, which is isn't there a difference between the kinds of cases that have been concluded to be substantial risk under Jackson and Virginia and this case where the lack of evidence is a technical lack of evidence? It's a technical. You didn't have a QE. You had an expert, but you didn't have a QE.
Well, I mean, if this were just a technical lack of evidence, then I do not think that from Johnstone to McIntyre to Green to Chapman would all be couching this in constitutional terms.
Well, respectfully, I do not read anything about constitutional terms in Johnstone.
Well, I mean, if
It's not there. It's a statutory determination.
If Johnstone wanted to interpret this strictly as a statutory interpretation, they could have looked at the statute and said, it doesn't require QEs, we're done with this conversation.
Could have, but they were doing statutory interpretation, and they decided in interpreting the statute, they were going to interpret it this way.
Yes, they said in a way to avoid constitutional issues. I didn't get to the issue of the the right to appeal a habeas petition. But I would just say, Wyeth is the law. That says it's the law. I think it's a jurisdictional issue. Wyeth says that, you know, if the government brings an appeal of granted habeas writ, then it is determined to be, it's rejected non obstante, which means in contrary to any other law. That's essentially the definition of a jurisdictional issue here. Okay, the government cannot bring this claim. The cases that they cite, Newton and Perez, those cases are not habeas cases because they do not ask the courts for immediate release. There's no case in Massachusetts that I've seen where where a petition for habeas corpus was granted, where an individual was released, and on appeal that was withdrawn. It has never happened.
So all you have to do is ask for immediate release.
No, all
and
you have to
get
do is
habeas.
be entitled to immediate release.
All right.
And if immediate release is granted and you're let go, it's over. I know I'm over, but
Well, I don't know. I don't know if it was said at 15 or 18, but I have another question anyway. Because I don't understand enough about the post-trial processes that are available to you in an SDP case. And I had not focused on the conversation we had earlier. I guess it's a civil case and you're under the civil rules. So the motion for new trial, the criminal procedural motion for new trial, Rule 30, not available.
well, it's interesting, Your Honor, because new trial motions are brought in SDP cases. Personally, I don't know what the relevant authority is for bringing them. But a lot of situations, we know we have ineffective assistance to counsel claims that can be made in SDP cases. We know that those sort of claims involve information that's not normally part of the appellate record, vis-a-vis affidavits from the counsel. So those are brought
where
as,
am I going to find anything on that? If I'm trying to understand what process might and should apply in this context, are there cases that discuss that? I mean,
You know-
Judge Sachs talks about 60B4, which is,
That's a great question, and I honestly, I'm not sure I know the answer, but I mean, one thing that you can see in the decisions is cases where this court and perhaps the SJC have ruled on motions for new trial brought in SDP cases, rather than just direct appeal. Off the top of my head, I do not have the names of any of them, but I know they've been brought.
Thank you.
And
But he can petition once every 12 months under Section 9. He can file a new SDP petition.
he can petition, it takes more than 12 months to go.
But he
to
can
go
file a
forward.
new one.
Right. And of course, a petition means that you have to be legitimately committed in the first place. That's one of the elements of Section 9. So thank you for your time.
If you could file something indicating what says the rules of civil procedure don't apply in SDP proceedings.
sure.
That would be helpful.
Straight away, thank you, Your Honors.
Thank you both. Our next case is 23P1038, Department of Children and Families versus Mother and Another. And if I understand correctly, Attorney Gallup will, I need to start with the appellants. Attorney Russell will argue for 12 minutes, Attorney Fabish for 3, and then on the appellee side, Attorney Gallup for DCF 5 minutes, Attorney Driscoll-Weiss for one of the children 5 minutes, and the other 2 attorneys for the other children 5 minutes. Is that correct?
No, Your Honor, I will be arguing on behalf of all 5 children. The attorneys for 2 of the children have just reserved time to introduce themselves. As
Okay.
it's helpful to the court, I can do that instead.
Yeah, I think what I have on the sheet here might be incorrect. So what's your understanding of the time for DCF?
I believe we were 8 minutes and 6 minutes.
8 and 6? 8, 6, and 1 and... All right. We'll see how it goes. All right. Thank you. So, Attorney Russell.
Thank you. Good morning. May it please the court. Attorney Morgan Russell on behalf of the mother. Mother is asking this court to remand this matter back to the trial session, primarily because of the errors in the court's findings. The biggest issue here is that the court, in its own rulings, limited the child's testimony to that of their state of mind, not just his testimony, but all statements of the children. And mother would certainly submit that that includes statements made in the documentary evidence that is voluminous in this case. So they were all limited to the state of mind of these children, but the court relies heavily on these statements by the children throughout her findings, and finding there was significant domestic violence in the relationship between mother and father, and that relationship between mother and father is so intermingled and intertwined in the remaining findings of this court, and the finding of unfitness, this court has to remand it back to...
So did the judge say, and I apologize that I'm not as steeped in this as I perhaps should be, but did the judge say at trial, before the children testified, I'm taking this only for state of mind?
She did not say that, but there were lots of contradictory rulings regarding statements of the children throughout the trial. So
where do you get that the judge said, I'm only taking the testimony of the children for state of mind?
That's in footnote 2 of the court's findings.
Right.
And there were motions in limine filed as well. Unfortunately, I do not have that before in the record, but there were motions in limine filed as well. All exhibits were entered pursuant to those motions in limine. There's frequently... Oh, I'm sorry.
That's kind of a confusing footnote because number one, it says the subject child in a footnote to a phrase that's dealing with 3 of the children. And number 2, it cites the Mass Guide to Evidence section about out-of-court statements when they testified. So what should we make of it?
So what I would say, Judge, is that the footnote...
Particularly where she did seem, as you suggest, to rely on the in-court testimony, not just for state of mind, but for its truth.
Well, first, in that footnote, where the footnote is located is in where she's citing to the child's testimony. So I would say that that is why it's limiting not only the statements in the record, but also the testimony. I would say that the accommodations...
But it says the subject child and her, as if it's talking about one particular child.
Yes, but that specific child is a twin. The twin also testified. So it's unclear as to why she would only limit that one child. She doesn't say why. She doesn't distinguish between these 2 children who are the same age, which is really what is problematic with these findings, that the judge appears to be kind of all over the place, as she is through the testimony and the objections. And
I don't know what you mean by all over the place. I mean, the judge's findings seem to me to be very clear that she finds that there was domestic violence in the relationship, that she finds it based on a number of different facts, some of which I agree appear to be the child's testimony. But there's also a 51B, right? And doesn't the 51, isn't that good evidence, the 51B?
If you accept the child's statements in that 51B for the truth and not limited to their state of mind.
Why would it be just limited to the state of mind in the 51B? Doesn't adoption of Luke say that if the child's available for cross-examination and it comes in as substantive evidence?
If the child is available for full cross-examination, which is not the case
Okay, that gets
here.
to a different question. But, and that I understand, but assuming there were full cross-examination available, the 51B would be independent evidence of domestic violence from the same child.
Assuming it was, but it was not here. And unfortunately, the record is unclear as to what, if any, cross-examination questions were submitted to the court and actually followed up on. So we have, in the record, in the appendix itself, it has a plethora of questions requested by counsel to be asked of these children. The court cherry-picked, or chose, rather.
I just want to make sure I understand. In response to my question, your answer is they didn't have adequate cross-examination, and therefore adoption of Luke does not apply.
That's correct. I believe the court maybe foresaw this issue in limiting the child's statements. That would suggest that it would apply not only to the testimony of these children, but to the statements throughout the documents.
What about the testimony that bruising was observed on the mother?
I'm sorry?
What about the testimony or police reports indicating that bruising is observed on the mother? Isn't that evidence of domestic violence?
None of the police reports observed any bruises on mother. Not a single one suggested that. The police responded and they were concerned about domestic violence. All of the bruising is from the children's statements.
There's, well, that's...
No observations from the principal and...
I believe the principal suggested that other staff had described bruises on mother. I don't believe the principal herself said, she said that she had seen bruises from time to time. I don't know when those bruises were seen or observed. That was not the basis, I believe, of what the principal's concern was for the children. So I would suggest, again, that limitation that the judge did put in place really was a fatal error to her findings and would require remand, because that relationship between mother and father is a very big part of why this mother was found
The judge
unfit.
did not have to put that in place. The child testified to what they observed, personal observation, right? It's good evidence, right? So you're basically saying, the way I read footnote 2, because there was no such statement in the transcript itself, the way I read footnote 2 limited what was good evidence to just state of mind evidence.
Yes.
All of the evidence of domestic violence was limited in that way.
All of the children's statements regarding domestic violence.
So
which
you're
is-
saying the
yes.
only evidence of domestic violence came from the children?
Children. So yes, Judge, yes, that it would be mother's argument. Again, based on those accommodations that the judge herself put in place, and I would say she has the authority to limit evidence. She's the gatekeeper of evidence. If she so chooses to limit evidence, how she interprets it and uses it, she's empowered to do that.
And so what you then want us to do is take her specific findings that there was, I think she said ample, or a word to that effect, evidence of domestic violence, and consider that to be clear error because she didn't follow her own rules, as you read footnote 2.
That is correct. That is correct. And I would suggest as well that because of that error in how she utilized the children's statements, is so deeply infects the rest of her findings that we need to remand for a new trial on this matter. And I would also just move on to my next point about post-adoption contact and the judge's legal error in not addressing or considering the interests of the children, what their wishes were, what their needs were individually. First, the court lumps mother and father as a singular unit. It's very clear from the record that mother and father were completely separate visitation resources for these children. They had completely separate relationships with these children. Father was absent primarily for the entirety of the proceedings, was not visiting the children. Mother was visiting the children consistently, and while there were some times where mother did miss visitations, the bulk of mother's visits were positive, they were consistent, and mother was appropriate. The judge also, in a singular conclusion of law, also puts all the children into one bucket, and these are children ages at the time of trial from 12 to 1. The 3 children, of course, testified, state of mind, they wanted to be with mother, they wanted to see mother. 2 of them wanted to live with mother, and the judge completely disregarded that, did not take that into consideration, and it was an error of law in failing to do so under veto.
So post-adoption visitation, to order it, requires a finding, number 1, that it's in the best interest of the child, and 2, that an order is necessary to protect those child's interests because those children's interests, because otherwise the custodian may not permit the visitation. Here, the prospective adoptive parents both said they would be open to visitation if the mother and the father stay sober and act appropriately and so forth. So even if the judge erred in finding this wasn't in the best interest, why was an order necessary?
Well, only one pre-adoptive resource testified at trial, and she testified that she would be open to allowing phone calls if mother is appropriate, and that she wanted a relationship if mother was sober. I think the evidence also suggests that mother and this adoptive resource had a pretty decent relationship up until the second removal of these children, and that relationship deteriorated thereafter. So while she's testifying to all these things, she's not allowing mother phone calls with the children.
Well, I don't read the testimony of the pre-adoptive mother that way. Maybe I'm looking at the wrong section, but on pages 2401 to 2402 of the transcript, she's asked, if in the future mom were to change, be sober, be able to be a positive influence for kids, would you support her having any role in the children's life, assuming you had adopted them at that point? And the pre-adoptive mom says yes.
Yes, she does.
And she says absolutely, I'm sorry. And
Yes,
same
but-
for the father.
Yes, but my concern is, Judge, again, that we've got different children with different needs at the time of trial as well.
But you said just phone calls. I'm not seeing where the limitation to phone
So
calls is.
further down, I believe it's at T2426 is where she says that she would allow phone contact if she had custody. This is a grandmother who has never reported mother being under the influence of substances, has never reported a poor outcome of these children having contact with mother. She's observed this mother with these children, but all this time she's not allowing phone contact between the children and the mother. So if she were inclined to allow this contact and she has no observable concerns on her own part, the concern is that going forward, she's not going to honor those, even when it is, as it was at the time of trial, in the best interest of the children to have and maintain contact with their mother, especially the older 3 children. And again, the legal error here is not just that the court declined, it's that the court failed to even consider all of these factors in making its decision to decline. So I would argue not only is it just that there is potential harm in the grandmother, saying these things because she's being questioned about it, but also that it was it was a requirement by the judge under veto to take these things into consideration and address them for each of the children, not just summarily saying it's not warranted here. And the court did not do that, and that itself requires a remand as to that issue in particular, where it's been such a long time as well. Coupled with the issues and the findings, the complete disregarding of consideration of these children's best interests with respect to post-adoption contact requires remand. It requires a new trial. It's been 3 years since this trial started. Lots of things have changed, and mother would be asking for a remand on those grounds.
Can we go back to the question of the taking of the child's testimony? Where in the record am I going to see how the outcome of that testimony would have been changed if cross-examination had been allowed? I take it that the argument is that cross-examination was limited. Is that right?
Yes.
Okay. Where am I going to find anything that indicates that there would have been a material change in testimony as a result if cross-examination had been allowed?
So the issue there, Judge, well, first, the proposed questions are in the record. However, the cross-examination, it appears from the record that they were emailed to the court, but none of those questions were in the court file. So I don't know that we can actually look at that to see what questions could have been asked that were not asked. I don't know how we can do that when everything came from these children and it was limited.
Okay, but leaving that aside, I'm trying to, so the argument's made that you haven't shown prejudice, and I'm trying to understand even what you articulate as the prejudice. In other words, one argument could be the child was making it up. If cross-examination had been allowed, that would have been that would have come out in front of the judge. I don't see that argument in the briefs.
So
I don't see anything that suggests where the harm was from the way that the examination was conducted.
Well, some of the questions indicated a question of whether these children were promised anything in exchange for staying with their grandmother, who was the placement. I think that would certainly suggest why the children are answering questions the way they are, where they received that information, whether someone told them to say these things. None of that was asked of the children. And I think that in itself could be the prejudice. We don't know why the children were saying the things they were. The visit with mother the day prior to their testimony was canceled intentionally by the department to influence these children's testimony. And I think that's really important in looking at should these parents have been given the opportunity to fully cross these children and really talk to them. I think that all signs point to these children could have been influenced, whether it was intentional or unintentional.
Where is
and
the
that's
evidence
the issue.
that the children could have been influenced? Where is that evidence?
It's in the questions that were proposed to the court and the department conceding in a hearing that they intentionally canceled this visit so that the children would not see mother prior to their testimony.
But during each child's testimony, the judge took a recess and conferred with counsel and then came back on the record and asked more questions. Can we infer that those questions were suggested by counsel for either or both parents?
I don't know. I can't answer that question because I don't know what questions were submitted to the court because it was not in the court record.
Thank you.
All right.
Thank
Thank you.
you.
We'll leave it there, and we'll hear from Attorney Fabish for the father.
May it please the court. Good Good morning, Your Honors. Matthew Fabish on behalf of Father. To address the issue that the court was just getting at, where's the prejudice and what are the questions that could have been asked or should have been asked to highlight that prejudice? I would suggest that evidence of that can be found in the record at Record Appendix 4, starting from around page 770 through 780. And what those questions, now that of course lists all the questions that were proposed by various counsel, but what the questions that the court specifically declined to ask went to were issues of bias or influence by the social workers, bias or influence by the proposed pre-adoptive placement, statements about what they had been told about parents' progress or lack of progress. All of these types of issues are issues that normally would be allowed, particularly if the court is going to allow the state of mind question or the state of mind of the children to come into evidence and rely on that, then the basis for that state of mind becomes highly relevant. And it becomes relevant to the question of what is in the children's best interests, both from a resolution of the ultimate termination of parental rights trial and from the question of visitation. So you have at least 3 of the children at some point expressing a desire for visits with father. You have at least 3 of the children expressing a desire for visits. You have a social worker, you have testimony from the children, live testimony from the children that they want visits, and then testimony from the social worker backtracking on that. And the court credits that testimony from the social worker to go to the state of mind of the children, but doesn't allow parents' counsel even to suggest the questions of how are we going to inquire as to what the basis for the...
It was the father who asked that the children be called in the first place.
It was, Your Honor.
Which is kind of unusual, I think, in termination cases or C&P cases.
It can be, although...
So it's the judge's discretion.
It is the judge's discretion, although, Your Honor, this court's cases are very clear that testimony is supposed to proceed normally unless there is some reason to limit or alter the testimony. And particularly in this case where we've had evidence of children crying when visits were missed, to not allow the children to see the parents in the courtroom seems to...
Well, there's also testimony that they were afraid of the father in particular, wasn't there?
I think that the court has an obligation to fashion the least invasive, the least limiting method of testimony for the children. And so in this case, we lack an expert affidavit as to what those accommodations would be.
If it was discretionary with the judge to allow them to testify, and the judge had said, here are the conditions I'm going to set, and your client had said, well, then I'd rather not call them at all under these circumstances, and there wasn't any testimony from them, how would the result here be different?
Your Honor, I do see I'm out of time, may I?
Yeah, go ahead, sure.
Essentially, Your Honor, the court in that hypothetical poses between 2 losing situations, right? Either you take limited cross-examination that fails to go to the heart of the questions related to the children's state of mind, or you take no cross-examination.
Okay, I'm saying no, if there was no testimony at all from the children, what do you contend would have been different in the judge's decision? What did she rely on from the children's testimony that was critical to her decision in a way that prejudiced your client?
I think what she did is she failed to credit the children's testimony in a way that required, I think litigants have the right to present both affirmative and negative evidence and to elicit that from their witnesses. And when the court fails to credit that testimony as a result of accommodations that are put into place without expert support and without an expert affidavit indicating that those accommodations are required to limit the traumatic impact on the children, which is the only reason this court has identified as a legitimate reason to accommodate for children's testimony, then again, I think that result is not consistent with due process.
Thank you. All right, we'll hear from the appellees. I think I've gotten straight now with the time division. It's 8 minutes for DCF, 5 minutes for lead counsel for the children, and 1 minute for each of the others is what I was told before. Okay, so Attorney Gallup from DCF.
Good morning. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment of the lower court as there was overwhelming evidence of unfitness in terms of unaddressed domestic violence, unaddressed substance abuse, housing instability, and ongoing criminal activity for both parents.
Can you address the domestic violence point?
Sure.
Is there evidence of domestic violence separate from the children's testimony?
Yes, there was. It's the department's position that the children's statements within the documents and in the court investigation come in for their full probative force, and also the social worker.
So where is that? The 51B?
Yeah, and the court.
Are there other than the 51B? I looked at a 51B where one of the twins is her report of father striking mother. Other than that, is there other documentary evidence of domestic violence that you're relying on?
So in the 51B, I believe also in the court investigation, but in addition to that, social
You
work.
believe also in the court investigation. I don't know what that means.
I don't have that in front of me right now. I didn't. I focused more on the fact that social worker Drew herself testified that one of the children, one of the twins, told her that she saw father punch mother and mother had a black eye. So that was not in the, that was testimony from the social worker.
Oh, that's hearsay, right?
No objection made, and also, I mean, whether the child is a party opponent, you know, they're part of the case, that came in.
There's Drew's testimony, and there's the 51B. Okay, the 51B has a wart on it, which is your opponents say that the cross-examination of the children was artificially limited in a way that is inconsistent with, I can't remember the name of the case, but it's 55 Mass Appeals Court case. What do you say to that?
Adoption of Luke?
No.
Sorry.
The question that the
Adoption of Ronnie. That's the name of the case.
The
The question, so they say, look, you can't consider the 51B either. You can't consider the children's testimony, you can't consider the 51B. For the same reason, which is that there was an artificial limitation on the cross-examination of the children that was inconsistent with our law. What do you say to that?
Well, I believe that the questions that were posed to the children while they were at trial did go to some of the information that was contained within the 51B document. I don't agree with my sister that the footnote 2 limiting the testimony and whether it's one child or all children to their state of mind was applied to all of the evidence in the case.
Let's assume I agree with you on that, or assume we agree with you on that. You still have the issue of whether there is prejudicial error as a result of the way that cross-examination was conducted, or the examination was conducted. You know, Ronnie seems to say that you need to allow cross-examination by the parents of the children. And here, there was no cross-examination, right? Everything ran through the judge.
Well, I don't agree that you have to allow cross-examination of the children, because adoption of Arthur, you have the judge interviewing the child in camera with, I think, child.
How old was the child in adoption of Arthur?
I don't have that information in my mind right now. I don't know.
And Arthur predates Ronnie, right?
I believe it does.
Yeah, it does.
So,
I mean, there's sort of a fundamental question here of what due process does or doesn't require with respect to a testifying witness that's establishing, you know, key evidence in a case.
So in these matters, due process just requires that a parent has the right to, effectively rebut the adverse allegations against them. And they had that opportunity through the other witnesses.
If that argument is that you can't cross-examine, you can put in other evidence. That's just not consistent with most constitutional law that I'm aware of. Cross-examination is the most fundamental way to examine a witness.
So the judge did ask each child if anyone had told them what to say when they were in court. The judge also asked the children if anybody had spoken to them about court. So there is that in there where the judge questioned whether, you know, there was any influence of the children's testimony, and then also the fact that the statements in the documents are consistent with their testimony several years later. I mean, this is just one piece also of the parents' unfitness determination, the domestic violence and the nature of their relationship was just one piece. Father had ongoing criminal activity, and mother had unaddressed substance abuse.
Just so I'm clear, the children's testimony goes primarily to, number one, domestic violence, and number two, where they prefer to live or how they feel about the parents, perhaps relative to the pre-adoptive parents. Is there any other issue on which their testimony or their out-of-court statements would be important to the case?
Well, they did also speak to physical abuse by the parents.
Okay. All right. So if we were to put aside the children's testimony altogether, is there anything, would the case have come out differently, I guess is my question.
I mean, I don't believe that it would, because while this case was ongoing, it was tried over, 21 non-consecutive dates. The parents, traveled to Ohio. They were stopped by the trooper. Drug paraphernalia, which was tested and led to an indictment against one of the parents. This tracks the pattern of mother being present in the car with father when father is arrested or charged and searched and found with several different kinds of narcotics and charged with distribution or trafficking. The fact that now, I guess, taking only the children's state of mind, just kind of jump around a little bit, it demonstrated that they feared their parents, and the fact that the mother heard this testimony, went on this journey with father, and then testified later that she didn't see any problem with continuing to engage with a person who the children represented they were afraid of, demonstrates that both parents were unable to kind of elevate what was important for the children. How can we support these children above their own needs to continue to engage with each other? So, I mean, there are various aspects of this unfitness beyond just whether there was domestic violence between mom and dad. Thank you so much.
All right, thank you. So, Attorney Driscoll-Weiss, I think you get 5 minutes.
I do.
Yes.
Thank you, Your Honor.
Thank you.
May it please the court, Roberta Driscoll-Weiss. I represent child number 2, child number 3, and child number 5. However, given that the appellee children filed a joint brief, I will be arguing on behalf of all 5 children today. If there are no immediate questions out of the gate, I'd like to begin by introducing you to the children, if I could. Child number 1 is a boy. He's now 15 years old, and he's placed with a maternal relative who is his adoptive resource. Child number 2 is a 10-year-old boy. Child number 3 is his 10-year-old twin sister, and they are both placed with their paternal grandmother, who's their adoptive resource. Child number 4 is an almost 8-year-old girl, also placed with paternal grandmother. And
I actually do have a question out of the gate. Maybe I'm a little late to the gate, but you say that it's...
Hop on through.
Okay, thank you. It was permissible to admit the children's statements in the DCF records as long as they're subject to cross-examination. That's Luke, I guess. But here, with the limits on cross-examination, was it appropriate to consider their statements in the DCF records?
It was. I think the parents expected the lower court and this court to treat these children like they're just small adults, and they're not. their children. And given that situation, the case law in Massachusetts is very clear that the judge can make accommodations for children that he or she might not make for adults. That includes in-camera testimony, it includes,
Right, that's testimony, but we're talking about the rule in Luke, which is you can admit their out-of-court statements if they're subject to cross-examination, yet they were not really subject to cross-examination here.
I think I disagree that they were not really subject to cross-examination. First of all, I'd like to point out that because father disputed the manner in which the trial court was going to examine the children, he didn't even appear. So it was impossible for him to listen to the children's testimony, present new
But
questions.
counsel was there, and counsel seemingly would have cross-examined if given the opportunity, given all the questions that were submitted that weren't asked. So,
And there was nothing improper in the manner in which the trial judge conducted the examination of the children. So had the, and as I...
Say that why? What case are you citing for the proposition that having the trial judge conduct the examination is the equivalent of cross-examination?
In adoption of Ronnie, this court held that it's an order allowing children to testify outside of the presence of their parents is allowable.
Well, so the judge, as I understand it, the judge ordered the parents will be on Zoom.
Correct, Your Honor.
So that part of Ronnie, I don't think is an issue before us. What we're concerned about is not allowing the parents to cross-examine. And the judge at one point said, well, I don't want these children to be cross-examined by 7 different lawyers. Could the judge have said, okay, DCF can do the direct and the 2 parents can cross-examine, and I'd ask counsel for the children to direct any questions they have either through the court or through counsel for DCF?
I think under adoption of Arthur, the judge could have done any number of things. Adoption of Arthur notes that the delicacy of cases involving interest of children, which may be adverse to those of their parents, a trial judge is not restricted to the ordinary modes of trial.
Well, so this happened on July 28th, 2021. Was anything about not allowing the parents to cross-examine or the parents' counsel to cross-examine to do with COVID restrictions?
I don't specifically recall, Your Honor. I apologize. I don't have a memory of that. It's possible that was the case. But if I could just go back to Arthur, Arthur says the trial judge may examine the children privately and may also avail himself of affidavits or other reasonable and proper sources of evidence. So the trial judge, quite honestly, could have accepted an affidavit filed on behalf of the children, which would have allowed no cross-examination.
An affidavit is the child stating under oath X, Y, and Z.
Correct. In lieu of testimony.
Okay, but what we're talking about here is the admissibility of DCF records, so second-level hearsay.
Well, so I think what I'm trying to get at, Your Honor, is that the parents were allowed to present questions for cross-examination purposes. They did so. The judge, as Your Honor noted, the judge took a recess, presumably to go back to the questions, continued examining the children, and at no point during that hearing did counsel for mother or counsel for father say, wait, we have more questions that we want to ask. In fact, they didn't raise this issue at trial. They raised it for the first time on appeal. So
Whoa. Which issue?
the issue of being denied the opportunity to cross-examine the children.
Didn't they object to the judge's, the judge entered an order indicating how she was going to examine, how examination of the children was going to proceed. Wasn't there an objection to that by both father and mother, or at least one of them?
I was referring to the specific questions that the trial judge asked the children. At no point did counsel for mother or father say, well, we have more questions. Could you please go back and ask them, have they been promised anything in exchange for their
The
testimony?
process itself was objected to.
The process might have been objected to, and that objection failed, because under Arthur and Ronnie, it was an acceptable process. The trial judge, I think it's important to remember that in making her determination, the trial judge relied on documentary evidence from
a DCF social worker who's been a DCF social worker for 21 years, regarding the potential harm to the children if their testimony was taken in the normal course.
The difficulty is that there's a fundamental right at issue. Okay? And when there's a fundamental right at issue, usually we have due process rights, and one of those rights, which is a pretty important right, you'll find it in most of the cases dating back for hundreds of years, is the right to cross-examine the witnesses against you. And so, you know, the notion that, well, this is okay because Arthur says it's okay, Ronnie says it's okay, I don't think either case says you can literally stop them from cross-examining, which is what happened here, I think. I'm just, you know, you would say, no, they weren't stopped from cross-examining because they got to ask questions and the judge asked those questions, and you've indicated some that were asked, and that matters to me because otherwise, you know, it seems a little touchy to me.
Well, and I think the appropriate time for the parents to have raised the objection that they had specific questions that they had submitted that had not been asked by the judge would have been to do that at trial.
Okay.
But I realize that my time is up. I would like to just close with one thing. These children have been out of their parents' care. The 15-year-old for something like, I don't know, almost 50% of his life. The two 10-year-olds for 80% of their lives. Child 5 has never resided with her parents. Child 4 was born during the course of the first care and protection. Child 5 was born during the course of the second care and protection. I would point the court to adoption of Inez, which says that while parents have a constitutionally recognized interest in maintaining the family unit, a child's interest in freedom from abuse or neglect is absolute. I would also point to, I'm sorry, the citation escapes me, but essentially it says stability in the life of a child is important, and these children have this only stability they've ever known since this case had ended. So on their behalf, I ask that this panel affirm the judgments, decrees, and orders of the trial court, finding the parents unfit and terminating their parental rights. Thank you.
Thank you. All right, so we can hear from counsel for the other children if you would like to be heard. I'm not sure we have particular questions for you. I do not. But a minute.
May it please the court, my name is Elmarie Curran. I represent child number 4, and I'm here today to ask that this honorable court affirm the judgments of the trial court terminating the parent's parental rights and accept the plan of adoption by parental grandmother. Since the court indicated there was no questions, I just wanted to introduce myself.
Right.
Thank you.
Thank you.
Good morning. May it please the court, my name is Sandra Ferrigno. I represent the oldest child, child 1. And he is also asking that the judgments be affirmed and that he be freed for adoption. And I just wanted to add just 2 points. One, mother did testify on the last day of trial, and I apologize that I don't have the exact date of which date she testified, that there could have been financial and verbal DV in her relationship with father. And that was at the end, towards the end of the trial dates. The other thing with respect to the way the testimony of the children was taken, the judge did take those questions ahead of time from counsel, asked the children questions, and then asked each child individually to go wait outside in the hallway, and then allowed trial counsel to confer with their clients to come up with additional questions based on the questions that she asked. And then that child was brought back into the courtroom.
Were you present?
I was not present, Your Honor. That child was brought back into the courtroom and asked those additional questions. So I would argue that that was a type of cross-examination. It did put father's counsel at a disadvantage because father was not present, but mother's counsel was able to confer with her to come up with additional questions. And in fact, the record does reflect that there were additional questions that were asked by the judge once each child was brought back in.
Thank you.
If there are no further questions, I rest on our brief.
All right. Thank you. You want to do a third case now?
I'm happy to. It's up to you.
You want to do a third? Okay. All right. We'll hear our third case, and then we'll take our mid-morning break, which is 23P1056, CHILES trustee versus LITTAUER. Whenever you're ready.
Good morning. May it please the court, my name is Demetrius Ioannidis. I'm counsel for the appellant Dana Chiles as a trustee of the BRABERN Realty Trust. The first issue in this appeal is whether or not the trial judge abused his discretion in dismissing the remaining claims of my client through what the court referred to as a willful failure to provide discovery and to comply with court orders. I begin by looking at the judge's order on the first page of the decision, where the judge specifically made a finding that said that my client did not respond to any of the 10 requests for documents, and as of today's date, the plaintiff still has not responded to any of the requests. That was in May of 2023. I submit to this court that that is wrong. The record clearly reflects that in April of 2018, my client's then attorney filed a response to the document production, specifically saying, I have no documents responsive to the first 9 requests, but I am producing documents responsive to the 10th.
Right, but let's talk about damages, okay? Because I read the hearing transcript today where your opponent asked for dismissal of the case, and your opponent represents a number of times that I've received no documents that support a claim for damages, and I did not see your prior counsel in any way, shape, or form contradict that.
It's a fair question, Your Honor. The answer to that is simply that when you have a defamation claim, when you have a negligence claim, I'm not sure that you need documentary evidence to prove a defamation claim. You can have testimony of witnesses come in and say, that person lied about me, said this about me, said that about me, and I have been harmed. And how have I been harmed? By all these factors here. So the remaining claims that were sort of closed off by the dismissal of the action.
So what were the claims that were left?
So defamation, negligence, breach of contract, 93A violation, breach of an interference with a contractual relationship.
I didn't see negligence listed in the many discussions of what claims were still alive. I don't think I saw negligence.
I believe it's part of the amended complaint that we have included in the...
It was in the amended complaint, but when the various parties were discussing which claims were alive, I saw defamation, fraud, 93A, interference with business relations, and potentially a breach of contract.
I think the summary judgment disposition that was entered into, and I believe we have that in the supplemental appendix, that disposed of the counterclaims filed by the appellee, disposed of the claims with respect to my client's foreclosure, invalid foreclosure, and the request to quiet title. All these claims were resolved by the summary judgment, and the judge denied the motion for summary judgment on the remaining claims.
So, counsel, you just made an argument. Again, I read the hearing transcript before the judge who had to make a decision on what was being asked. It was not made. The argument you just made was not made. Now, maybe the reason that argument was not made is because in the pretrial memorandum, which has itemization of special and liquidated damages, the answer is determination of damages in the nature of interference of business relations, lost business profits, goodwill, unfair debt collection practices, illegal foreclosure. Oh, sorry, I didn't read carefully enough. Defamation. Okay.
Again, Your Honor,
only mention is the $449,652.15, right?
Fair enough, Your Honor. I think the argument that was made by Attorney McGuire at the time was that an individual can testify about these through memory and can be cross-examined.
Can testify about which ones?
In terms of the damages, the amount of damages. A person can say...
Which of those damages can they testify about?
A person can testify that I sustained the loss of X amount because I had an event...
Without any documents whatsoever. I have no documents, and I don't remember anything, apparently, when asked at deposition. But I can testify...
Absolutely, Your Honor. Yeah. The testimony is subject to cross-examination, credibility determination.
As a matter of law, could it fail?
Was he asked about lost profits or damages at the deposition?
I believe that a lot of the questions at the time of the deposition were not answered. But again, because of memory questions, and I believe there was nothing subsequent filed by the other side requesting further responses to the questions or the deposition testimony. But I think the key here is why...
Doesn't it amount to an argument that was made to the judge to the effect that, look, he's produced no documents whatsoever. As a matter of law, he cannot prove lost profits because lost profits can't be speculative. As a matter of law, he cannot prove lost goodwill because he hasn't identified a single piece of goodwill. And isn't that a pretty good argument?
That's a motion for summary judgment, with all due respect, Your Honor. That part of the case ended. What happened in this particular case is the motion to dismiss was filed...
You don't think they can bring it forward? You don't think they can bring forward the same argument immediately before trial to the judge? Say, look, there is no evidence. Judge, this is exactly what they said. Judge, you should not go forward with this trial because there is no evidence that could support any of these determinations, lost profits, goodwill, lost business relations.
They could have raised that, Your Honor, but the question is, how did it happen? It happened through a reply brief where the request is filed now.
Mr. McBride never objected to that. He never objected to it. This argument was made on the merits. The argument that you're making now was made on the merits. Am I right or am I wrong?
I think you're right about that, but the question is, how do we prove damages, Your Honor? And again, it goes to the finder. The fact finder has to make that determination. A judge can't look at a statement made by a lawyer that says, you haven't produced any documents. That's an incorrect statement. That's a misrepresentation to the court. He did respond to documents. He filed whatever documents he had, and his explanation throughout the case is, I don't have any other documents that were lost at the foreclosure.
I want to make sure I understand what exact set of documents we're talking about here. There was discussion at the two hearings in May of 23 of an exhibit list just having been turned over to LITTAUER's counsel. I think it was P number 78, but it's not available on mass courts. Is that something we need to look at? Because there was some discussion at the end of one of the hearings in May of those documents needing to be turned over. And I don't know whether these are documents that are documents of record or documents that are, I mean, public record like at the registry, or documents that are in the court file, or what they are. But is that set of documents something that's in dispute here, and whether they were turned over?
I believe that those documents were obtained by the appellee through subpoenas, and there were other public records that have been provided, or at least cited by the appellant in that particular case.
But would you have been able to rely on those at trial, given the earlier order, I think by Judge Kelly Brown, or perhaps it was Judge, one of the other many judges, saying you can't rely, if you don't turn over the documents that were requested in the request for production, then you can't rely on any documents at trial?
I'm not sure that's what the court said. The court said you are going to be precluded from introducing any documents. The court didn't say you cannot rely upon testimony, you cannot rely about any other stuff.
Okay, so were the documents that were listed on that pleading number 78, the document list furnished on May 12th, I think, of 23, would those have been available for use at trial?
I believe
by your client? Could your client have offered them?
I believe that these were public records and records that had been provided through a subpoena to the other side.
Well, we don't have that document, the list, in the record, so we don't know what those documents were and whether they would have gone to the damages issue.
It's in the opposition, and I think that's all we have, the opposition to the motion in limine, and I think in the trial, or in the transcript of the hearing, there's some references, but I don't have that, Your Honor. Again, Your Honor, what I'd like to bring back to the court's attention is the fact that this case was dismissed for two reasons. Willful, this is what the court said, willful failure to provide discovery and also comply with court orders. Now, it is important to note that in June of 2022, the parties were ready for trial. The appellee specifically said, I'm ready for trial. Filed a motion to conduct voir dire, filed a motion with witnesses, filed a motion in limine. In 2022, the statement by everyone was, we are ready for trial. The only reason the trial didn't happen is because my client was sick. There was no request that no documents were produced at that point in time. What The motion in limine was to reconfirm, and this has been consistent. We want to reconfirm that you cannot provide any document, you cannot produce documents at the time of trial because you have been
They
precluded.
adjusted the relief that they were asking for. They adjusted it in the reply brief, and they adjusted it orally. There was no objection made. The matter was addressed on the merits.
That is a fair statement, Your Honor. But again, the judge's decision is on the basis of willful failure to provide documents. And that is the standard. And if you look at the case that I have
It
cited,
may be two different pieces.
I'm sorry?
It might be one, under no circumstances can they prove damages, and therefore they can't prove their claims. And two, in any event, willful failure, sanctions for willful failure to comply with discovery. They are two different things, right?
They are two different things.
Okay.
And on the first part that the court relied on in making the decision to dismiss the remaining counts, the court is wrong. Because Keene versus Brigham and Women's Hospital clearly says that you cannot use Rule 37 sanctions if a party cannot produce documents that it does not have. This is a very Supreme Court
Who has the
case.
burden on that? Does the requesting party have to prove that the documents exist but are not being turned over? Or does the responding party, your client in this case, have to prove that the documents don't exist?
Your Honor, if a party is requesting documents, there is an obligation to take certain steps in order to do what you need to do in order to comply with the request for production of documents. In this particular case, the response of my client has been consistent. The documents were lost in the foreclosure. There's no further affirmative duty by any court decision in this case. No judge ever said to my client,
Where am I going to find in the record where your client said that in a pleading or some sort of formal, as opposed to a representation from counsel at argument? Where am I going to find I don't have any of these documents. The documents used to be at Place X. Place X was foreclosed on. And
It's not anywhere under oath, is it?
it is not.
Okay.
It is not, Your Honor, but it was in the response to the request for production of documents, and then when counsel came before the court on the motions and the oppositions that were filed, this is what was related to the court. There was nothing further from any court, any judge, saying you got to do X, Y, and Z. There's no affirmative duty other than a preclusive effect, and that's all we have in this case.
I was a little confused by the response, the opposition to the motion in limine, the one that was filed on May 5th of 2023. The motion sought to preclude your client from offering any documents at trial, as I read it. And your opposition said two things. Number one, the motion is moot because Judge Kelly Brown's order already precludes me from introducing any documents not produced by June of 2018. And then it goes on to say, I only intend to introduce documents filed or obtained via subpoena and record documents. So on the one hand, you're saying, if I didn't produce it before 2018, I can't introduce it. And on the other hand, you're saying, but I can introduce all these documents.
I think
And so could the court not have said, you know, you're trying to have it both ways here, and this is, after all this time, is sanctionable?
Yeah, I think the court could have done that. That's not what the court did here. And I think what happened is that these documents were obtained, these other documents through a subpoena were obtained by the other side. And I think
So were you saying that despite Judge Kelly Brown's order, if this case had gone to trial, you would have been permitted to introduce the documents that your opponent obtained by subpoena?
That wouldn't have been my position, Your Honor. There was a clear order. And I think in compliance with that court order, I think what the intent was to say that there are public records out there and that as a matter of right, I can I can introduce public records.
Would those have gone to the issue of damages?
Your Honor, as I sit here today, not having those records in front of me, I cannot say yes or no. But again, that is not a question that was addressed by the judge at a time of trial. It was simply dismissed because, and again, Your Honor, if I look at the case and I look at the references, what apparently happened is the judge that looked at the motion in limine in March of 2023 and made the notation that you haven't produced any documents, that was because it was in the motion in limine. Documents were produced. And a response was filed that said, we don't have any other documents, and that has been the consistent story.
So the photos were produced and possibly a spreadsheet that no one can find?
some events and things of that nature. That is
So what was the other thing?
some photographs of events that had been scheduled.
Photographs, what else?
Photographs. That's it. That's what I understand was produced at the time, Your Honor.
So let's assume that the burden was on the LITTAUER to show that the documents did exist and yet weren't being produced. Could the judge decline to credit in determining whether the documents did exist and therefore whether there was a violation or a willful violation? Could the judge have said, I just don't believe LITTAUER's, Mr. Child's assertion, not even under oath, that the documents don't exist? These are checks, receipts, bank records, tax returns, anything. I just don't believe that they don't exist.
That's a fair question, Your Honor, and I will agree with you. That's a credibility determination. But without testimony, how can you make that determination? There had to be testimony. So without the testimony, the judge simply relied on a motion in limine that was filed on a reply argument of counsel and said, case is dismissed. And that is not the standard. That is not the standard. Now, the appellee has introduced some cases. I'm sorry,
We're going to have to wrap it up. So one more sentence.
One more sentence is that there's some sort of an argument that has been made by the appellee that the final judgment that was apparently docketed by the clerk included a dismissal of the entire complaint.
Yes, and it did. That's the words of the final judgment. Now, that may have not accorded with what the judge ordered, but wasn't the time to fix that by a motion to alter or amend the judgment?
Your Honor, that could be, I thought about that, but the question is, when there's an appeal that has been filed, what happens then? I think the appeal is on the judgment itself.
You can file the motion. Yeah, the appeal is on the judgment. You can file the motion while the appeal is, before the appeal's been docketed here and get a ruling on it, but, okay. We understand your position on the dismissal of the entire complaint.
I rely upon my pleadings.
Thank you, counsel.
Thank you. Okay, Mr. Manekas, I believe. If I'm pronouncing that right, I'm sorry if I don't.
Manekas, Your Honor. Thank you. Good morning, Your Honors. May it please the Court. Jason Manekas on behalf of the appellee and cross-appellant Thomas LITTAUER. I'd like to just pick up where you left off with my colleague, Attorney Ioannidis, and some of the questions, specifically one by Justice Sachs, was, were there any documents and would they have gone to damages? In fact, to be clear to the Court, there were very limited documents turned over in the course of discovery, and you'll see if you read through the
photos?
I'm sorry?
The photos?
Yes.
Anything else?
No.
Okay.
And those photos are actually contained in the record appendix?
Yeah, we've seen them.
Yeah. And those photographs very simply are Mr. Chiles, the plaintiff.
Right. Your position is they don't prove damages?
They don't. In fact, it actually shows he...
So what case says you must have documents in order to prove damages? Obviously, if Mr. Chiles were to take the stand at trial and say, these were my gross receipts before and after the foreclosure, and these were my expenditures, which would have to be netted from the gross receipts to find a net profit figure, and look at how they plunged. He'd be subject to all kinds of cross-examination. You don't have any documents that support any of what you say.
Yes.
And, at the time of your deposition, you couldn't recall a bunch of these things, and now you recall them? I mean, that might be a devastating cross-examination, but is he not... What case says he can't even go to trial and put that issue of credibility before the jury? That can't be resolved on summary judgment, can it?
I don't have to answer your question specifically, Your Honor. I do not have a case with those unique facts that say, without documents, you must therefore dismiss it. I would submit that it does go to the general powers of the Superior Court and the trial judge to maintain their own calendar, their trials, in fairness. So in this case, what we have is...
I don't understand that at all.
I'm sorry.
The question is a question of what is sufficient to prove damages in the Superior Court.
Sure. I believe in the document, I don't have the citation. There's the Tech Plus case. We had argued it and cited it in front of Judge Callahan, Tech Plus, and it specifically talks about when you're talking about lost profits as an example, a measure of damages has to be proven to a certainty. And in connection with that, you must bring in documentary evidence and have evidence to prove those. The person there had testified, Your Honor, as to a loss And without specific documents, the court found that that was insufficient. So
Which
the
case is that?
Tech Plus, TECHPLUS.
Is it from
I
our
don't have
court
the
or the
site.
SJC?
I'm sorry, I believe it was an SJC case.
That surprises me, but okay.
But stepping back, this goes to the fairness of my client to proceed to trial and to be forced to trial. So we have an instance.
Different question. The question that Judge Sachs is asking you is simply what is sufficient in the Superior Court to prove damages? And there are cases that talk specifically about lost profits that say you have to be able to prove them with sufficient certainty. And if you can't, then your evidence fails as a matter of law. There are a number of cases that talk about that.
There are, Your Honor.
And I don't think, if those cases are specifically tied to having documentary support, that would be interesting to me and helpful, and I'd love to take a look at it. The thing that I think is running around here is you had the opportunity to pose the plaintiff, right?
There was a deposition in this case,
And
yes.
did you ask the plaintiff, what are your damages and what is your support for that? Is there a series of questions that goes to that were in the deposition transcripts? And were those, I mean, I saw a reference to that in the oral argument that he said, I don't recall, but.
There were a series of questions designed to get at what the damages in the case were. I, since the deposition transcript was not before Judge Callahan, made representations to the court. Those representations were actually accepted on the record at page 324 by Attorney McGuire at the time. Those representations in part were, and these were only part of this transcript, you know, what records do you have? What contracts do you have? Do you have tax returns? Who is the accountant? They were all designed to get financial information so we could evaluate whether or not there were any lost profits, whether there were any damages.
I don't recall, or I don't.
The answer was either I don't know, or no, we don't have an accountant, no, we don't have records. So that precipitated, Your Honor, Judge Kelly Brown's order saying, if you don't provide documents by a certain day, you'll not be allowed to introduce any documentary evidence.
Are those deposition transcripts that you just represented to us, are those in the file somewhere?
The CHILES deposition, at least a good part of it, is at Record Appendix 48 to 84. And I do recall a lot of I don't recalls. Sorry for that confusing formulation. But it seemed to me that there were not questions asked specifically about damages.
Well, I don't recall a specific damage question, but if you're trial counsel and you're getting discovery, there were questions about what contracts existed, what tax returns existed, what were your financial records, all of that. More specifically, the document requests that were submitted to them that they never responded to or provided any documents.
Well, they did respond. They said, we don't have documents. We don't have them. We're still looking. If we find them, we'll supplement. And they were precluded by several orders from introducing any documents that hadn't been produced, you know, some
correct.
years before trial was scheduled.
That is correct, Your Honor. That is correct.
What is the, okay, so that's the state of the record with respect to whether they can prove, for example, lost profits, lost goodwill.
Yes, Your Honor.
Perhaps interference with business relations. Doesn't really go to defamation. I mean, he says, you know, maybe he has testimony about I was defamed by X. Apparently there's no motion to dismiss this that says it's not sufficiently particularized, which it has to be. So how does the judge dismiss the defamation claim?
So in this case, Your Honor, we're not just dealing with the substance that I had argued, but on the substance, you can't, in my opinion, go through a deposition testimony where you're asked questions about what occurred in the case, your financial records, be asked to turn over documents that support your claim, violate a series of orders, and then just go to trial and say I was defamed. There's no evidence There's nothing on the exhibit list that goes to defamation. So allowing a person to go in blind, in theory, if you could prove defamation without any documents at all, I understand the point.
That's the problem. There's nothing on the exhibit list that goes to defamation. I don't know that. What we have is a dismissal with a record that's doesn't talk about defamation. Quite frankly, doesn't even address the claim, and that's difficult to deal with.
So the court had asked about...
What you've done is you've pivoted from an argument that says they can't prove damages to an argument that says this was an appropriate sanction for their failures in discovery. And on that one, my question would be this. There's a finding of willful failure. What in the record justifies the judge's finding of a willful failure to produce?
The discovery specifically requested things such as bank records, tax returns. It's a horse farm, customer contracts and the like. Nothing was turned over. The
Representation is made,
yes,
we don't have them.
Yes. A nebulous statement made by an attorney, understanding that what they did turn over was a bank record that's in there from 2014, which was 2 years prior to the lawsuit and 1 year before the foreclosure.
Not helpful. So they said, we don't have them.
So they don't say we didn't have them.
So what's the willfulness?
So Judge Callahan can determine that just because you say it doesn't make it to be true. We don't have any records. How is it that...
Well, how can he do that? Doesn't he have to have evidence that it's false?
Yeah, I think it is false, Your Honor, when a person gets up, being precluded from entering documents, and says, I don't have any records. The fact that Mr. Chiles has no bank, because this all occurred post-litigation, Your Honor.
Instinctively and intuitively to both you and I, counsel, that may be false, but doesn't the judge need evidence? Didn't we need a motion to compel?
And doesn't he have to make a finding that it's false before he finds willfulness?
There's no motion to compel, right? Is there a motion to compel?
There was a prior motion to compel that said you failed and you can't produce any documents
And that's when they introduced that's when they submitted their response that says, we don't have anything except these photos.
Sure. And then there was a further motion that resulted in saying you can't put in any evidence of damage.
Okay, so that's the sanction. And that, by the way, is probably the sanction you asked for at the time, right?
Yes.
Okay. And at the time, did you ask for dismissal of the case?
So the motion in limine was filed prior to the June 2022 hearing. And at the time, we had asked to dismiss all remaining claims. There were then a series of events, not relating to discovery. There was the last-minute continuance of that and the failure to comply with any of those pretrial obligations. There was then, in November, Judge Dunnigan's order saying, hey, you need to comply with these specific deadlines, and if not, you're not getting a continuance with a trial in March of 2023. They failed to comply with Judge Dunnigan's order. Then they came back with yet another reprieve after failing to comply with Judge Dunnigan's order, and they sought last-minute relief from Judge Gilday.
You're talking about the and/or?
Yes.
The appearance and/or opposition. So...
Well, Judge Dunnigan's order, Your Honor, I apologize. Judge Dunnigan's order in November basically said you need to be ready to trial and comply with these deadlines.
Okay, but they got an extension.
Yes.
With this order that Judge Gilday, I guess, saying if there's been no notice of appearance filed by successor counsel on or before April 28th of 23 and/or no opposition to the motion in limine, this matter shall be dismissed for lack of prosecution. So the and/or suggests one or the other is sufficient to prevent the matter from being dismissed. And a notice of appearance was filed, and then an opposition to the motion was actually filed 7 days later. But even that aside, isn't that, and/or ambiguous?
I don't believe so, not at all, Your Honor. I think the and/or from Judge Gilday, who had looked at the record.
I think he was ordering them to respond to the motion in limine, and if they didn't, he was going to determine that they'd failed to prosecute the case?
Yes. That is our position, Your Honor, that they had to do both. They needed appearance, and if
says-
they failed to do either of those, it would be dismissal. If you phrase it the other way, it's the or. But
Okay,
it was...
so looking at Judge Gilday's order as it originally was issued, which is Record Appendix 214, successor counsel shall notice an appearance in this matter on or before April 28th of 23. Plaintiff is also ordered to file any opposition to defendant's motion in limine by such date. So any opposition, that doesn't say he's ordered to file a response so I know what his position is. That's saying any opposition is must be filed by that date. in what he eventually filed, he said, I don't really oppose this except as moot because they've already gotten all the relief they're asking for. So why wasn't it at least a reasonable interpretation by Attorney McGuire, I think at the time, Child's counsel, to say, I didn't think I needed to file both an appearance and an opposition. I didn't really oppose it.
On that point, I would disagree with the interpretation, Your Honor, because Judge Gilday's order in the footnote talks about how he had reviewed the record, the memo, the motion, and he was concerned about their trial readiness, which was an issue before him. He then says that if there has been no appearance filed,
so they shouldn't treat it with
and/or
indifference.
it shall be dismissed.
Yes, and/or.
Okay.
And didn't Mr. Chiles satisfy that condition? An appearance was filed by successor counsel on or before April 28th.
At its core, Your Honor, I think this goes beyond just a Rule 37 decision. Rule 37 was amended, which doesn't require willfulness in Massachusetts. So
But
even
then
if
we have
there's no...
subsequent case law saying to dismiss, you really need willfulness.
Well, but this is an instance where we questioned Judge Callahan, Attorney McGuire, and myself how this trial would proceed. As an example, with no evidence of damages,
Okay,
no
so
documents.
then I think you're shifting gears to an argument that without documentary evidence of damages, the court could just dismiss it because it was a waste of time.
Under these facts and circumstances, it would be a waste of time because there was no documentary...
How do we know what the jury would believe?
Well, it would be prejudicial to my client to proceed with a jury trial without having a witness saying, I don't know anything, having no records and no proof of
It might
damages.
be prejudicial, but it would be would it be unfairly prejudicial, which is the question where he wasn't asked, your client didn't ask him specific questions about damages that I could see in the deposition, and he has every opportunity to cross-examine him at trial.
It would be prejudicial because a witness would take the stand and say, I had $1 million of customer contracts, and as a result of your actions, I lost them. We have asked for those customer contracts. We've been denied access to them.
Yeah, and
They've
the
been
only
precluded from
sanction that you
introducing
had
them.
asked for up until the reply brief was that they be precluded from introducing any documents at trial, and you won that. You won that. So, you know, the difficulty is really with the process that's come before us for this dismissal to have occurred, okay? I personally, and I have no idea how other people feel about it, I think they're going to have a heck of a time as a matter of law proving lost profits, some of these other things, but some of the other claims, defamation, he has a right to get on the stand and argue.
I believe under these facts, Your Honor, with the various violations of pretrial orders, Judge Gilday's order, Judge Dunnigan's order, the cumulative effect of them, I think that Judge Callahan was within his rights. I also see that I'm just about out of time, so I did want to make one more point. I think that, 2 quick points. One,
You are out of time, so we've read your brief. If there's something that's not in the brief, we'll hear it, but...
I would just like to...
It's on the untimeliness of the appeal?
More specifically, with respect to the order dismissing all claims, that was not briefed. I think that plaintiff's counsel should have moved under Rule 58 to amend. Under Rule 60, the one-year period has lapsed. And if this court, on that issue, we, since all claims were dismissed, could not have taken an appeal on the obsolete mortgage statute. So I just point that out to the court, that in the context, we couldn't have appealed it, and we did note it. Thank you, Your Honors.
All right. Thank you. We'll take our morning recess, and we'll be back in 15 minutes.
We'll stand in recess. be seated.
All right, we're back on the record for our last two cases of the day. The first of them is 22P1152ML versus Safe Passage. It's a partially impounded case, so we know that that counsel will observe those limitations. And Mr. Hardy Doubleday, we'll hear from you.
Good morning, Your Honors. I'm here representing ML against Safe Passage. It's our position that ML was an occupant who had tenants' rights, subjecting her landlord to use Mass General Law 239 if they wanted to eject her from the property.
Why do you call them a landlord?
Why do I call them a landlord? Because they had her sign a document which gave her some exclusive possession to the property. And that document also...
The document in the record?
Yes, it is.
Okay, what document should I be looking for?
That document was, it's basically her program, it's the policies and procedures. Okay? And if you look at that document, there's a checkoff for her getting keys. And it explains to her, hey, look, you have a locked food cabinet. You also have exclusive possession to this bedroom.
It says you have exclusive possession to this bedroom?
She had exclusive possession.
Is that what the document says? It uses the word exclusive possession?
No, I believe what the document says is here's your key to your bedroom.
Okay.
And now here's the exception.
Doesn't it also say we can move you at any time?
If we have a reason to do that. So we can move you if you're a family of two and you're occupying a bedroom.
Does it say we can move you at any time, or does it say we can move you if we have a reason to do that?
For reason. Let me...
For cause? Is that what you're implying, that there's a cause?
There's a cause element. It's not arbitrary.
In the document itself?
Well, let me not try and do this from memory, because that never works out.
Yeah, I apologize. I should have it in front of me, but I don't.
It's Record Appendix 9. Doesn't talk about moving, doesn't say exclusivity. I'm a little confused about what status you're claiming for ML, because there's no complaint. And when you started out about she was entitled to summary process protections, is she claiming to be a tenant, or is she claiming to be an occupant? What is the claim?
Well, Your Honor, we're relying on the YMCA case, right, where the judge goes, as an occupant, you are subject to 186 subsection 14. If your landlord wants to get you out, they need to use 239. So we're relying on the holding of that case.
Okay.
And in that case, the person was paying rent.
Right. Well, here, the Commonwealth is paying the landlord, Safe Passage, money to provide housing and additional services. There's consideration for rent here, much like a Section 8
First of all, is that in the record, what the Commonwealth is paying?
If you look at my sister's pleading, she says that they get money from the Commonwealth for their programming.
And why is that in any way equivalent to an individual paying rent? The fact that the Commonwealth is paying Safe Passage to provide writ large access to certain types of folk?
Because it's similar to Section 8. You're in Section 8?
Section 8 is identified to a particular person, as I understand it.
Not necessarily. It can be to a building. You can have a project-based Section 8 to a building. So you move into that building.
But a Section 8 tenant pays some percentage of their income as rent, I believe, don't they?
But if they don't have any income,
and
they don't pay anything.
have to be approved as an individual to that building.
Correct.
Yeah.
But if you don't have enough income, much like a person who's fleeing a domestic violence situation, you don't pay anything. 100% of your rent is paid by the government, much like 100% of the ML's rent was being paid by the Commonwealth.
Just to back up and put this in procedural context, this is an appeal from an order vacating or declining to extend what the judge said was a temporary restraining order.
Correct, Your Honor.
Right? Usually appeals from TROs or denials of TROs are not permitted. If it's sufficiently like a preliminary injunction, then there's some case law that permits it. But at any rate, this is at a very preliminary stage of the case before even a complaint was filed, and I'm wondering whether this was an abuse of discretion to decline to extend the TRO. She's still got whatever damages claims she wants to pursue. I'm not clear if she's still pursuing any kind of injunctive relief, but where's the abuse of discretion in not extending?
Well, Your Honor, what should have happened here is the judge should have said, go file an eviction. That didn't happen. And if he had said, go file an eviction, the order would have stayed in place until she was formally evicted.
Right, but that goes to the question of why isn't the case moot? Why isn't it moot now?
The case isn't
What
moot.
relief does your client want that this court can be involved in?
My client wants you to order safe passage to evict her rather than use an administrative
passage
process, which there was no record for.
Hold on. Safe passage cannot evict her, isn't that correct?
Why can't they?
Because, as I understand it, she's not there. And not only that, safe passage no longer is engaged in this building.
Okay, well, let's go to the first issue. She's not there. Well, if you order them to evict her, then her damages would be from when she left until presently. Because I believe my client is still
But she's
experiencing
not
homelessness.
precluded from getting damages. This was just you've appealed a ruling declining to extend injunctive relief. The complaint hasn't been dismissed. The complaint hasn't even been filed yet. But she's got a live claim for damages if she asserts it properly, doesn't she?
If you order them to use summary process, then she would be allowed to go back to that hotel that they put her in, because they didn't want to put her in the same building that she was in. And then they could, I guess what they would have to do is evict her from her program, and then that would stop them from having to pay for the hotel.
So you're saying that safe passage's only avenue of getting her out of this shelter is summary process, that they can't use injunctive relief as a means to get that? What if there was another person in the shelter who got a 209A against your client?
That's different.
Why is it different?
Well, because my client was the one who filed the TRO, so it wasn't safe passage. It wasn't that safe passage was saying my client was doing something that was so dangerous he immediately had to leave. If someone had a 209A issue and safe passage was following the rules of that 209A, saying, okay, we have two people here, one can't be within 100 yards of the other, you can't stay here, you have to leave. The police will arrest you if you're still here. You have to leave. That's what makes a difference.
So would safe passage have to go through summary process in that situation?
Well, if the person didn't voluntarily, if the person left their things there and didn't voluntarily make arrangements to pick them up, yeah, I guess they would have to.
So you're saying summary process is the required avenue, not that, and there can't be another avenue of either allowing or, what if safe passage had filed the motion for the injunction to get her out?
So if they had filed a TRO, well, one, you don't file TROs in housing court to get people out. That wouldn't work.
Okay.
So I think I've addressed your question there. But if she were selling drugs, yeah, you could file, I guess you could file in Superior Court if you caught her selling crack cocaine, and you could get her out almost immediately.
Okay, so why is this case any different than that?
Because she wasn't doing that.
But she was doing something that Safe Passage concluded put other people in the building at risk.
Okay. So you have...
Not selling drugs, she's doing something else that puts them at risk. And so they say, let's get her out of here.
Okay, so this happens all the time. And what you have is a for-cause eviction. You have a lease in the form of this policy agreement which doesn't say you
You're calling it a lease, and you're, I think, counsel, you're well aware, because it's in the briefs, that whether or not it's a lease or a license is really the fundamental issue in this case, right? It doesn't call itself a lease, and there's no rent associated with it.
Well, again, you can have a Section 8 person that doesn't pay a dime. And if you have that same Section 8 person who is violating their agreement
Saying
with...
she's a Section 8
No.
person.
I'm trying to walk you through what the avenue is to get someone out when they don't follow the rules. You have a for-cause eviction rather than a no-cause eviction, which is essentially what they try to do. They said, you're violating our rules, you need to leave in 3 weeks, or 2 weeks. I think that was the first one that they sent her.
Just to be clear on what she's claiming, didn't she allege that she was paying rent of $125 or perhaps $120
I think
a month?
that might have been, I think that might have been a Scribner's error on her part. But, because I think...
She doesn't presently claim that she was
No, she's
paying
not
rent.
presently claiming that.
And the judge found that she was not.
What's that?
The findings of the judge were that she was not
No,
paying
she's
rent.
not paying rent. However, there is a consideration for the rent being paid by the Commonwealth, which is acknowledged by Safe Passage. We are getting paid to provide these services, which include housing, from DPH.
I mean, the problem I have with that is that I'm pretty sure if I were to look at the contract between the Commonwealth or whatever there is between the Commonwealth and Safe Passage, it's not going to call it rent.
Of course it's not.
Right.
Of course it's
So
not.
that's a characterization that may not be consistent with the facts and may not even be in the record. It's not in the judge's findings at all.
You're not going to call it rent, but I'm going to call it consideration for a right to stay at the property. And under the YMCA case, where...
But what the government would be doing is establishing that Safe Passage is sanctioned by the government to have people writ large who fit a certain set of characteristics stay there, not that your client would stay there. That's what that's about. It's not about your client specifically. Section 8 is about specific people. There's a big difference.
Again, Section 8 can be project-based, so it's not about specific people. And then in regards to, I think in regards to my client, yeah, she does fit a certain criteria, therefore she's allowed these services, and in their policies, they didn't say, hey, you're only here on a temporary basis. You're only here for 10 days, and then we need to review it. In his decision, he even says there was no duration, that some people have stayed there for years. That, to me, creates a tenancy. Creates a tenancy because you have exclusive possession. Yes, you could be subject to a move, but there needs to be a reason. You're basically in a rooming house. But you have a lock, you have a key. People can't come into your space.
So just to come back to the procedural posture here, this is an appeal from, we'll call it denial of preliminary injunctive relief. So it's an abuse of discretion standard. The judge said she paid no rent, she didn't have a right to exclude Safe Passage from entering her room or moving her to another room, so she's not very likely to succeed on the merits, and the balance of harms favors Safe Passage. Why is that weighing and balancing an abuse of discretion? Doesn't mean she can't succeed on the merits, but this is just a denial of preliminary injunctive relief.
I think you got it wrong.
Which part?
Which part? I think if you look at how he analyzes the YMCA case, he says, okay, they paid rent. And I'm not sure what was in the record at that point in regards to whether he was made aware that DPH was paying for this or not. So I guess he could have said it on those grounds, I guess on rent.
She paid no rent. She didn't have a right to exclude Safe Passage from entering a room or moving her to another room.
They couldn't do it arbitrarily. They can't just say, hey, look, we want to take a look at the coloring of
Where are
your
these
wall.
rules written down that they can't do it even arbitrarily or in a way that she might characterize as arbitrary? Is that in
If you
DPH
look
regulations?
If you look at their pleading, it says they could move her subject to the needs of the program. So it wouldn't be, we want to be in your room right now because we like the windows in your room.
But you were seeking injunctive relief, or to extend the injunctive relief. The burden of proof would be on you to show that her right to exclude safe passage was sufficiently tenant-like or sufficiently occupant-like to get her the protections of 186.14 in the same way that YWCA did. The judge didn't assess the evidence that way at the preliminary stage. If it goes back, you could put on more evidence.
Correct.
But why was it an abuse of discretion for the judge to
I think he had enough evidence where he could have said, you are an occupant under the YMCA case.
Maybe he could have. Maybe there's some gray area in there about how similar this is to YMCA. And as the Safe Passage points out, this is an issue that goes beyond the shelter that Safe Passage was operating, and probably is of considerable interest to DPH, which may be funding these programs statewide. So should we be in the position of ruling that, yes, on these facts, she was an occupant?
Yes.
So everyone who, at the Pine Street Inn or Rosie's Place?
Oh, there's a difference. There's a difference. It'd be one thing if you have cots in this building, in this room, and people were staying in this room, and they had access to a locker where they kept their personal possessions. It's a whole other thing if you have a locked bedroom. It's a completely different, it's apples to apples, oranges to oranges.
The difference for you between Pine Street Inn and your client's situation is solely that she had a lock and key?
No, a couple of things. Lock and key, she had exclusive possession, yes.
Because of course she's a domestic violence victim. They're going to give her a lock so that she can lock her door.
Okay, if you let me finish, she had a lockable bedroom.
I'm sorry, but
she had a
I'm sorry if you think I'm interrupting you, but it is actually me who needs to understand this case.
I'm trying to explain that to you.
Okay.
So she had a lockable bedroom. She had policies and procedures that said, you can stay here as long as you want. Did not have an end date on it. And there was consideration paid by a third party, acknowledged by Safe Passage. That creates her tenancy.
All right, let me ask you, I'm sorry, your time has expired, but I do have a couple questions. Judge Sachs said that there's no complaint in this case, and I'm confused as to how the case gets started without a complaint. You couldn't have a case in Superior Court without a complaint first.
Well, it's frequent that tenants, especially pro se, or litigants pro se in housing court will file a TRO. And they're asking the judge to make some sort of immediate finding on the TRO.
Judge takes that, and how's the case entered in the housing court docket without a complaint?
It's as a TRO, as a temporary restraining order, and that's it. And that's what they rule on. And then what could happen from there is the tenant could file a separate civil action, or the tenant files a verified complaint with the TRO. Here, she simply filed a TRO.
So that leads to the question I asked earlier, which is then why isn't the case moot?
Because if you rule that he needs to...
What relief? She asked for a TRO to prevent them from having her leave. Okay, so her relief is, I want to stay in this building. Is that relief at all available at this point?
Yeah, well, what could happen, because what they did is they put her in a different, I believe they put her in a hotel. So what could happen is they put her in the hotel, they file summary process.
Why isn't that a request for different relief, which is, before I was asking for relief that they not take me out of this building. Now, actually, what I want is that they put me in a different building, a hotel.
No, she didn't want that. She wanted to stay where she was.
But the point about mootness is there has to be relief that the court can grant.
The relief the court can grant.
It was requested.
Right. The relief the court can grant, okay, which her previous counsel made very clear is, if you want to get me out, evict me. File under summary process.
Okay. All right.
Thank you.
Thank you. And we'll hear from Attorney Elkins for Safe Passage.
Good afternoon. May it please the court, Marissa Elkins for safe passage. This court in Cerez said, quote, where the administrative process has stumbled, the courts, as ultimate protectors of constitutional rights, may apply remedial statutes such as GL 186, Section 14. In Massachusetts, temporary emergency shelter services for people experiencing domestic violence is provided by a network of nonprofits overseen and regulated by the Department of Public Health. Organizations like Safe Passage, who, until May 2023, provided these services, must comply with the DPH's administrative contract and submit to their oversight. This included adhering to guidelines promulgated by the DPH to establish procedures that, quote, ensure that participants in residential programs operated by entities under contract with the DPH through its Bureau of Community Health and Prevention Services are afforded a full, fair, and impartial opportunity to challenge decisions to terminate from residential
Why
services.
doesn't that give her some kind of right that therefore would require the invocation of summary process before she can be removed?
Well, to that I would say that the language used in Cerez is if the administrative state stumbles. The administrative process did not stumble here. Judge Kane did not err when he terminated the TRO, and Safe Passage at all times administrated its program according to DPH requirements, and LM was afforded all due process to which she was entitled in this administrative process. Cerez does not stand for the proposition that summary process is required for all terminations of folks from programs like these. It stands for the proposition that if the administrative process that is in place fails, that would be an appropriate place for a court to look.
Which case are you talking about?
I'm sorry?
Which case are you citing for that?
I was citing Cerez.
Are you talking about Cereze? Or I don't know how you say it. S-E-R-R-E-Z-E?
Yes.
Doesn't that stand for the proposition that if someone has sufficient ties to the property to be determined to be an occupant under the statute, then you have to use the procedures of summary process in order to get them out.
Your Honor, I think Cerez was...
So if there's some kind of contractual arrangement as to which the plaintiff might be a third-party beneficiary, doesn't that speak toward them having some kind of rights as an occupant?
Your Honor, I think there are rights as an occupant and participation in this system. I think that perhaps in response to Cerez, that the way that the DPH has set up these contracts with these organizations was to address that, to address a need for due process, some due process considerations. There are several fact-specific things
about... Then why didn't you have to do summary process then?
Because her due process rights are protected within the guidelines required by the DPH, and she got the full, unlike in Cerez. So in Cerez, that record did not show, there wasn't great indication of what, if any, internal processes residents were afforded. To the extent that you can glean from the facts what happened in that case, procedurally, it was either inadequate or not followed.
I thought your argument was going to be, yeah, there's a grievance process, but it doesn't grant her any rights. There's nothing in that grievance process. I read it. There's nothing in the grievance process, as far as I can tell, that says that this impartial government person who you can appeal to can order Safe Passage to keep the person in the building. In other words, Safe Passage has the unilateral right to terminate her. And yeah, there's a grievance process, and she gets a chance to talk to people, but there's no remedy. There's no stick at the end. That's what I thought you were going to tell me. If there is a stick at the end, then I think it's starting to sound like maybe she's a tenant.
Well, I think any resident in a program like this has got to have some procedural due process rights, and that is satisfied within the requirements.
Why is that? Why do they have to have procedural due process rights? Not the government. And these people can say, "I'll take you in," and I'm taking you in entirely at my discretion, and I will send you out at my discretion as well. Why couldn't that be the arrangement? I don't understand.
Well, the government is funding this, right?
The government, and that's the answer. If you wanted to just be a good doobie in the community and provide this kind of shelter without any without complying with the resources. You could do that, but then you would certainly be subject to the requirements of the housing law and the statutes that govern that. In this case, there is a dire need for this kind of services. It's not housing to particular people, it's temporary emergency services to people experiencing domestic violence. In that space, that is a cooperation between nonprofits and the Department of Public Health, there was a recognition that where there's, I would suggest, and I'm not the DPH here, as you mentioned, I believe it was you, Justice Englander, who mentioned they have a stake in this, that stepping into that space is a need to have a grievance process, to have some measure of appellate or appeal process and somebody looking over that there are some minimum standards.
Is it your understanding that during the time that grievance process is being engaged in, the tenant has a right to, or tenant, I'm not going to say tenant, the person has a right to stay at the place until it's resolved?
No, I don't believe they have a right to stay at the place until it was resolved. In this,
as if Judge Grant's hypothetical is taken, and the person is caught selling drugs on the premises, presumably they can get them out right away. They can grieve all they want, but they're already gone, right?
Correct, and safety of other folks staying in the place. That's absolutely, I'd agree with that's actually the case. In this case, on these facts, it's moot, though, because from the moment she was terminated from the program, Safe Passage voluntarily, without order of the court, housed LM in hotels throughout the whole litigation of this process. So even if this court were to find, which I disagree that would be appropriate in this circumstance, but that summary process were required, the question of damages, if any could be raised at this point, is also moot because she was housed through the whole thing.
Does she have a damages claim?
As
I understand it, as was represented by your opponent, she's filed something called request for TRO, and that's it. There's no complaint.
I would say she does not. I would say she does not. I just to answer the hypothetical question of could it be, sent back to the motion judge?
Could have a damages claim. There might be a statute of limitations issue now. I don't know. But that would be Chapter 184 or 186, Section 14, right?
I'd agree with that. I think that's correct.
Just make sure I understand the mootness argument you're making. So Safe Passage still exists. It just doesn't operate the shelter anymore. Is that correct?
That is correct.
Okay. And is there any dispute that Safe Passage doesn't operate the shelter anymore? I didn't hear ML disputing that. ML's request, their argument this morning was really directed at going back to the hotel, not going back into any shelter operated by.
Yes, that's correct. And they don't even have the contracts with the hotels that they utilize to provide that temporary shelter. They're out of the temporary shelter business entirely. And the question of mootness, what is at least as important as the fact that neither, the Safe Passage doesn't have anything to gain in terms of its operating procedures or what it does going forward because they're not doing that anymore. LM has long since, there's out of that housing.
Are you talking about an exception to mootness for capable of repetition in the evading review? Is that what you're getting at here?
Well, I was just going to say the party who has absolutely the most at stake here is the Department of Public Health, and they are not a party here. This has the potential to have significant implications across, an already overburdened system.
Whether this goes back with us, an order that there be preliminary injunctive relief or not, DPH could still be brought into the case, presumably by Safe Passage alerting DPH to the fact that these issues are percolating and DPH could intervene or so on.
Yes, and that was actually discussed at the motion levels, whether when all of this was being litigated in the housing court of whether or not DPH should come in. The judge never sought to hear from them, but did hear evidence and took into evidence, and it's in the supplemental appendix, all of the contracts and requests for, the request.
Both of you handle this case in the trial court?
I did, but brother counsel did not.
Counsel did not.
I have a question for you about the applicability of summary process. Your opposing counsel says that summary process is the only avenue for safe passage to get ML out of the shelter. 239 Section 1 says, if a forcible entry into land or tenements has been made, if a peaceable entry has been made, and the possession is unlawfully held by force. So once she's moved to the hotel, are they saying that she's entitled to have the hotel paid for by safe passage? I mean, it doesn't really fit within the typical summary process rubric because she's not unlawfully holding tenancy of the shelter by force.
Are you asking me if that's my brother counsel's
softball.
name? Yeah. I think nobody was held by force. There was no forcible entry. She actually left the physical premises voluntarily, as far as I
Was
understand.
locked out, wasn't she? Didn't they change the locks, or am I remembering wrong?
I could get back to you with that exact fact. I don't recall. I think she probably turned her key in, but I don't want to speak out of turn on the record.
Well, the key wouldn't work very well anymore if they changed the locks.
They don't even own the building anymore, so, but it is also important to note that throughout this litigation, there were a few hearing dates and ongoing discussion. It was safe passage throughout all of it, whether ordered by the court or not, even prior to any court order, was providing her with housing while, with the hotel, while she availed herself of the internal grievance process and then the appeal with DPH, which was upheld. And I read Judge Kane's decision to essentially say, licensee, the administrative processes of that were required by the DPH were in place here, were followed here, and are adequate protection. I think Suarez does stand for the proposition that in a situation like this, it is conceivable that if those processes break down, that is one potential avenue that somebody could.
So you're arguing that Suarez recognizes some kind of exception to the summary process laws for, if you have an alternative way to deal with the person, then we don't have to go through summary process? I don't understand why this is relevant.
Well, I guess because I wouldn't, I think it is the case that at some level, folks who are in these processes certainly have some protection and couldn't be arbitrarily, kicked out without some procedures. Suarez, in that case, if there were procedures in place that could have governed, I think Suarez, the facts of it pretty clearly say that they were either inadequate or not followed. In that case, the director said there was no appeal, we're locking you out. They went to something with
I'm missing your point, and I want to try to grapple with it. The fact that there's an administrative process, I thought, was relevant to the question of whether this woman is a lessee or a licensee. Now I hear you using it for a different reason, which is to say because she had an administrative process available, that was sufficient. Nothing else was needed. And that, to me, would be like saying it supplants the obligation to go through summary process in order to evict her. I don't know why. I don't read that in Cerezi.
Well, so putting aside the question of how we're reading Cerezi, which is an interesting case, both factually and legally, I would agree. I agree, actually, that there's an administrative process here that provides some due process protections and gives guidance to the programs doing these kinds of, providing these kinds of services, and that they were followed here. And that is in fact sufficient for the organizations who are relying on these to carry out, basically, if they're doing what DPH has asked them to do, then that should be good enough protection for the organizations that are providing these services to carry out their mission. Okay. So I think that's where I would leave that. My time is about to expire. Are there any further questions?
Seeing none, thank you to both counsel for your arguments. Very interesting case.
Thank you.
Very interesting. Well argued. Thank you both.
Thank you.
And our final case for the day is 23P 1407, U.S. Bank Trust National Association as trustee versus Moore trustee. And we thank both counsel for your patience in awaiting this argument. We've run a little over time despite having one case off the list, so, but we're just as fresh as ever and we're ready to hear your argument. So,
That's your opinion.
all right, so Attorney McCardle, I believe.
Yes.
Yeah.
Good afternoon, Your Honors. If it may please the court. Attorney Luke McCardle on behalf of appellant Catherine Moore as trustee of the Stafford Trust. So, as you know, this stems back to a foreclosure that occurred in April 20th, 2022. We attempted to get the foreclosure stopped through just a courtesy request at first, and then run into court to try to get a TRO to enjoin the sale. That was denied. Notwithstanding, we argued that we had equitable defenses regarding the situation and acknowledged that the trustee didn't really follow her fiduciary responsibilities in managing this real estate asset. She was the one living in the property too, as a little bit of a background. And I think, as you can see from the record correspondence regarding the emails, and
there was some question about whether this really needed to be brought through an interpleader action or whether it couldn't be resolved. But it seems to me that a central question here is what entitlement did your client have to attorney's fees and costs based on your assertion that this never should have been brought as a interpleader. Judge Buckley awarded you fees and costs in her March 27th order. All I saw in your motion requesting that was a paragraph about the equitable power of the court, but no real law entitling you to those fees. So what was it that you claim entitled you to those fees and costs?
well, I think the general nature of the interpleader cases provides on the plaintiff side, if
the plaintiff side, right?
There's a conflict, so I would suggest just reciprocating the equities of the situation.
What case says that?
There's not too much case law in this area.
Is there any
whatsoever?
Is there any that says
what I
a
cited-
defendant in a? Yeah, go ahead.
Yeah, no, what I cited in the brief is basically you take a look at some of the statutory implications regarding, say 231 Section 6, and you're able to glean on those.
Okay, but that requires a separate finding that substantially all the claims were frivolous and in bad faith and so forth, and an appeal from that would go to a single justice, not to us.
Sure.
So a
Sure.
6F theory would not be before us.
Sure, since she provided the attorney's fees, I suggest I didn't have to prove exactly what statute I was relying on in that instance.
But my question is about the process of Judge Buckley ruling on the motion for attorney's fees. As I read the record, in December 2022, Stafford Trust filed a motion for attorney's fees without an affidavit, seeking attorney's fees in the amount of $4,400. And then Judge Buckley allowed it and said, okay, file an affidavit.
Correct.
And then Stafford Trust filed an affidavit seeking attorney's fees, and this time they sought $7,500. But that was an affidavit with no motion for $7,500. The first one was a motion with no affidavit for $4,400. And Judge Buckley never ruled on that.
Correct.
It ends up going to Judge Callan.
Yep.
And by this point, it's up to $14,100.
Right.
And he basically says, a pox on both your houses, I'm not giving attorney's fees, denied, all caps. Denied,
Right.
denied.
Yep. No, I understand.
How do we say he abused his discretion?
Well, he abused his discretion because there was a number of, in my eyes, unnecessary pleadings that incurred some of these costs. And the reliance on Judge Buckley's order, that we have an order for attorney's fees, her order said, I don't know if it was in the written order or if it was part of what she said verbally, was just submit an affidavit of your attorney's fees pursuant to Rule 9A. And that's what we did.
But then you were seeking a different amount. You were seeking $4,400 first by the motion.
Right, correct.
And then you submit an affidavit, and by now it's I think, 7,500.
Right, that was the most current, the updated assessment, correct.
It is, it's in her order, specifically, that's what you're going to do. Submit an affidavit, you're awarded fees. What does the joint motion mean? Because it seems to me that that's pretty important here.
Correct, yeah, no, we're going to get to that, but the joint motion, it was a settlement, basically. We say, even though, once she denied the relief, Judge Buckley denied the relief, we want to deposit these surplus proceeds with the court. She said, no, you can take care of this on your own because you have a statutory and contractual obligation to do so.
Yeah. So paragraph 9 is the key part of the joint motion as far as attorney's fees go. Is that correct?
Paragraph 9, correct.
Paragraph 9. And paragraph 9 says the court should decide any such attorney's fees award.
Correct.
It doesn't say the court shall decide the amount of the award.
It
says any such award, which to me expresses some contingency that the court might not order any award.
No,
and it also reserves, if I understand correctly, U.S. Bank's right to appeal any attorney's fees award.
Correct.
Okay, so
my understanding of the language that says awards slash, in what you were just reading, so the paragraph 9, award slash amount. There was
yes.
So part of
any such award or amount.
Award or amount. So we decided that there was going to be a final. Judge Buckley's order was a final order. That.
Well, I don't know what you mean by final. I mean, it wasn't appealable at that time, so it's not final for appeal purposes. It may have been intended by her to resolve the entitlement to some fees, subject only to the establishment of the amount. So let's assume, just arguendo, that it was an abuse of discretion for Judge Callan to have revisited the question of entitlement to fees, and that he should only have determined the amount.
Correct.
It's that agreement still reserved U.S. Bank's right to appeal. So if he had said, well, gee, I don't think there's authority for fees, but I'm bound by Judge Buckley's order, so I'm going to determine the amount, and based on the affidavit, here's the amount I determine, then U.S. Bank would have appealed and said, Stafford wasn't entitled to fees in the first place. So isn't that really the central issue here, the entitlement and whether there is a legal entitlement, not what got raised when?
Correct. So there's a lot to kind of.
Well, you agree with what he just said? You just said correct.
Yeah.
and I got to tell you, do you think that what Judge Sachs just said is correct?
No. I think I just said there's a lot to undress there because there's a lot of levels to this because so the settlement agreement and the joint motion was not, once he endorsed and allowed that motion, it was already making Judge Buckley's order final. It wasn't a motion for
subject to appeal.
So assume that.
Sure, yeah, of course.
That's really important.
Subject to appeal.
Because as I read your entire brief, you were basically saying what you said earlier. This is settled. All claims are released. All arguments are released. We get fees. The only thing that's left. This is how I understood you were arguing it. All that's left is for the judge to decide the amount of fees, which they can object to. They can object to the amount, but not to the fact that fees have been awarded, right?
Right.
That's your position, isn't it?
That's the position, correct.
Okay, but what do you do with this last sentence that Judge Sachs has pointed out on paragraph 9? The parties reserve any rights of appeal applicable to said order in its entirety.
They certainly had once the order went in regarding the assessment of the attorney's fees, certainly they could appeal the entire order.
Including the arguments they'd previously made that there's no basis for awarding it.
Correct.
Okay.
So let's say we agree with you.
Yep.
And we remand this for Judge Callan or whoever, whatever judge, to determine the amount of fees pursuant to your affidavit. Then, once that is done, doesn't U.S. Bank retain its right of appeal?
Certainly.
Okay, so they would be back here, sitting in the other seat, saying there was no entitlement to fees. So again, isn't that the central issue? Was there authority to order fees for a defendant in an interpleader action like this?
It would be the central issue if there was an appeal that they exercised, certainly, and if there was an award. But at this point, we haven't even gotten to the award. I'm looking at the abuse of discretion because I don't think he had the discretion to rule on it as a motion. It wasn't a motion in front of him.
Well, please accept my hypothetical and tell me why there was authority in the first place for Judge Buckley to order the attorney's
Certainly.
fees.
I think what I cited to was the ability to look at similar statutes when it comes to a defendant seeking attorney's fees. One of them was 231 Section 6. There's case law. I don't have the cites in front of me, but I think it was the second paragraph of the brief regarding the award. So
maybe I can jump in and because I'm trying to understand something that was said earlier, which I think goes directly to this. You said, well, there's authority. The interpleader is an equitable proceeding, right? And that's historical, right? It's a proceeding in equity. And historically, the party that seeks interpleader asks for fees and gets it. Is that right?
Certainly, if there's a conflict.
There are cases that say that. The party that seeks interpleader can get their fees. All right. So why wouldn't it also be available to a court sitting in equity to also award fees to one of the other parties if they felt that the interpleader was improperly sought?
And I think that's the central argument. There's not a lot of precedent regarding this exact scenario with the interpleader and defendant actually obtaining fees. If you look at the two cases that were part of the brief, the Murphy case and Viva Alcovia, which is part of the brief, and the McRae case. I mean, the first one they provided through 244 Section 36. Which is akin to a civil action if they don't turn over the surplus in a timely fashion. So that was one of the statutes I cited when I asked for the interest and costs and fees separately.
They filed a motion for fees too, right?
Yeah.
Which was denied.
Yep.
And they wanted their fees to come out of the surplus.
Certainly.
Where were your fees going to come from?
I wasn't asking for fees from the beginning of this. We said each attorneys get their own fees paid for.
Once you did ask, where did you expect them to come from?
From the plaintiff for bringing in a claim that's frivolous in nature. And the Judge Buckley's order said plaintiffs manufactured a conflict. She said that it was frivolous within her own order.
You could have filed for fees under 231-6F, I suppose. Whether they would have been granted, I'm not sure, but.
Certainly, but because they were already granted, I wasn't compelled to file a further motion asking for something that was already granted.
I'm just looking for whether there was a way to award fees in this situation already, or whether we need to devise one on equitable principles under the interpleader statute. I mean, there's already a general provision in 231-6F for award of attorney's fees if cases rise to a egregious level of frivolousness.
Certainly, and I think the deterrence aspect of it is something that needs to be looked at in equity. You have these cases where you have homeowners a lot of the times unrepresented in financial straits, and sometimes there's some hardship, and they go through and they don't sell the house, but they have equity, gets foreclosed by contract and by law. They should be provided the excess proceeds when there's no conflict, and there's no conflict here. There was no right to file this interpleader action and ask the court to do their job.
But should Stafford Trust's lawyers' representation by email, you don't need to file an interpleader because the amount due to the second mortgage holder is really clear, BNY Mellon will agree to this. Is that enough to then make it unreasonable or egregiously frivolous for U.S. Bank to go forward with the interpleader action anyway?
Certainly. All three parties were represented by counsel. We were in touch immediately. I was in touch with the attorney from Goetta and Benson they were originally representing Bank of New York Mellon until it got turned over to the new firm during the interpleader case. In touch with them on the day of the foreclosure, the day before the foreclosure, requested a payoff to see, because I was running the court to understand what was owed to each mortgage holder, and there was significant equity, so I thought the judge might give us an opportunity to sell that within 60, 90 days or whatever it is.
Why didn't you ask for your damages earlier?
Honestly, I didn't think this case was going to carry on. I thought they would concede. Once Judge Buckley entered that order that said, no, you have to distribute it on your own, and they're getting attorney's fees, I thought it should have, it carried on, and then.
They got
just-
their money in like July, and Judge Buckley's
Yeah.
order entered in March, is that right?
Yes.
Right after argument, though. She didn't sit on it. Her argument, her decision was pretty close to right after the argument on the request for fees, I think.
Wait, say that again?
She didn't, I'm just trying to get
When
a
the
sense
surplus
of
was
delay.
released? You're saying when the proceeds were released?
No, I'm saying that it doesn't matter.
Okay. In any case, I think the equities of the situation, if you look at this opportunity for someone to line their pockets, and I'm not saying that was the intent, but it certainly appears that way, there has to be some deterrent level. My clients are now paying me more than what they were demanding from the beginning, and I relied on those orders and advised them, and then I can't rely on this order because another judge comes in and flips it upside down. And certainly there's no specific statute that I referred to when asking for those fees.
I mean, one way to look at what Judge Callan did is that they continued to object to whether the fees should be paid, and he read the record and decided there wasn't a basis. That's a way to look at it.
Right,
He didn't
provide anything in the record to suggest why he did what he did, certainly, but he certainly forced our hand into settlement. If you were there for the hearing, he definitely took this over and kind of pushed us out the door, so to speak. So I would say just looking at the equities, and there's enough underlying case law that supports there's contractual provisions. There's two statutes that deal with the right and those entitled to the surplus of a foreclosure, and then to have someone come in here and not release those proceeds for a long-standing time. If you look at the Murphy-Wachovia case, it's a good precedent for
You
that.
didn't invoke those, okay. You're over time. So.
Yeah, I'm over time.
All right.
All right.
Thank you.
Thank you very much.
All right. We'll hear from U.S. Bank.
Yes.
Attorney Precob.
Yes. Good afternoon, Your Honors. Attorney John Precob for U.S. Bank. If it may please the court, I believe the court is correct that there was no authority for Attorney Buckley to award attorney's fees based on the law that's been cited by the appellant. There is no law to support the right to fees.
If you can get your fees, why can't another party get their fees if it's equitably appropriate?
What I would say, Your Honors,
Why is it a one-way street? It's an interpleader proceeding. You asked for your fees. Why is it a one-way street?
I believe, Your Honor, because the purpose of the interpleader is for that party that is depositing the funds with the court to have it resolved have the other parties resolve that amount of money, and then they want to be resolved of that case, of having any responsibility for that money.
But why should they get their fees to do that? Yeah, they're stuck in this awkward situation. Two people want the same money. So what? Why should they get their fees?
I mean, historically, with interpleaders, Your Honor,
Okay.
that's what happens. That's what happens.
Okay, so historically with interpleader that happens. Why? What's the authority for that?
The authority.
Equitable powers of the court?
Yes, Your Honor. Yes.
So why
It's
don't
by statute now, isn't it?
Yes, I believe it is by statute at the moment. Yes.
statute provide for payment to the plaintiff, or does the statute provide that the court has equitable powers to conduct an interpleader?
I believe it provides for payment of attorney's fees to the party that has filed the interpleader. That's my recollection. I don't have that in front of me. I apologize. But
And really, it's written to just give fees to you and not to anybody else?
Your Honor, to be completely frank, I do not recall whether the statute has more general language about attorney's fees. I believe I would be.
Okay.
I don't recall it stating
Well, that can be resolved. We can pull down a green book and take a look.
Yes.
Or someone might want to get on their iPad. I don't know.
But honestly, I believe this case is should be more focused on the joint order, which Your Honor mentioned. It seems very clear to me, looking at the joint order and what Judge Callan did, that he did not abuse his discretion. There's the language, as you pointed out in paragraph 9, it doesn't state that an assessment of attorney's fees will occur. It states that, in paragraph 9, that subject to the court's determination regarding the award / amount of attorney's fees. In addition, if you look at the proposed, please remember, of course, that the two orders that were proposed to the court were reviewed by counsel for both sides, including counsel for the junior mortgagee. The final order, or strike that, the proposed order at RA, Record Appendix 335, it's actually RA 336, states at paragraph 3 that they want the court to rule on the request of defendant Stafford Trust for attorney's fees. I believe that, of course, attorneys know what they're reviewing something, they know what the language means, what it should mean. There was every opportunity and every right for Judge Callan to review the affidavit of attorney's fees filed by Stafford.
So you're saying because it says request and not amount, that means that they conceded that they weren't yet entitled to them?
Not that they conceded, Your Honor, that they were allowing for the possibility that Judge Callan would deny their request for attorney's fees. There was no language that said, in addition, no language that said, oh, file an affidavit.
You know, the problem I have with that proposed order was so bad because it had a court saying something that no court would say in an order. It was totally understandable to me why the court didn't enter it. Why would they enter an order to say that they would consider entering an order, which is essentially what the first paragraph said, right? But the problem I have is Judge Buckley had already ruled, and you had sought a motion for reconsideration and you lost. And so when the settlement comes along, and it is a settlement document. Granted, the releases are not clear, and it doesn't have a lot of the language that one might want. But when the settlement comes along, I think it's pretty clear that what was going on was you guys had said they're going to get fees, and all that we're going to be able to object to is the amount that they ask for, subject to our right to take an appeal. But instead, you guys, as soon as they filed, you again filed an opposition based on substantive grounds, right? You filed for the third time saying, hey, Judge, there's no basis for this. That seems to me that it was outside the scope of what you guys had agreed to.
I would respectfully disagree that the parties allowed for the right of U.S. Bank to oppose.
Object again, even though they'd objected twice before and Judge Buckley had already ruled? That was the settlement they reached?
So you bury the Superior Court judges under a blizzard of paper until they eventually throw up their hands and say, denied.
Your Honor, that was not our intent. We were responding to counsel for Stafford, them filing multiple motions, looking for their attorneys, motion to disperse, constant motions that we were responding to.
Can I just say on that objectively, you guys got paid a year before they got paid. And objectively, that can't be the way this process should have gone. Okay?
How so, Your Honor? Sorry.
Your client got paid, I believe it was August of whatever it was, 2022. And when did they get their money? August of 2023?
That was after.
How can that possibly be the way this was supposed to work?
Well, Your Honor.
Why can your client sit on their money knowing it's their money for a year? That makes no sense. So arguing some kind of, equities to me, that isn't going to work. Your client had the money. They were saying to your client immediately, we would like the money, and there is no dispute as to where this money should go, and yet it took a year and additional fees. I hope the next time around, it doesn't happen that way.
My recollection of the facts is that it wasn't that we sat on the money. There was discussions, there was communication.
Yes, I've read them.
Right.
They said, we know exactly how much should go to Bank of New York, and we would like the money to be distributed. And those discussions came within weeks or days of the time you got money. In like July of 2022, do I have that right?
I believe so.
Okay, and when did they get paid? 2023 sometime?
After both sides were litigating and fighting with each other.
Your client made a decision And I'm not making this up because Judge Buckley made these findings, made a decision to file something unnecessarily that prolonged the entire process. Like I said, I hope the next time around it doesn't happen this way.
Your Honor, and arguably, are we not discussing something that is not part of the appeal? Because what happened, what's on appeal is what Judge Callen did after he reviewed what the parties had already filed, the parties that had agreed on.
The law of the case would say Judge Callen can't countermand what Judge Buckley had found.
He didn't. He was consistent with what was Judge Buckley said. There could be attorney's fees awarded.
No, she awarded the fees. She granted the motion for fees, and she said, I just read it. And she said, what's going to happen next is they're going to file an affidavit.
Right, and she states in her order, her decision, find it. I apologize.
Counsel for the defendant, Stafford, shall submit an affidavit with costs and attorney's fees to the court for consideration. Said affidavit shall be filed pursuant to Superior Court 9A. The court will thereafter decide the amount of fees and costs to be awarded.
For affidavit of costs and attorney's fees to the court for consideration.
What about the word allowed in all caps and bold at the beginning of that ruling?
That was in the context, of course, that was in the context of a motion for attorney's fees. Agreed. But I think what has clouded the issue, is the fact that the parties ultimately did file the joint motion for an order. Counsel was involved. There was discussions. I was involved myself personally at the end of the process when the order was being drafted, orders, excuse me, and the staffer counsel could have changed the language in that final order. They certainly could have, and they didn't. They allowed for that opening that Judge Callen eventually used to order what he ordered and deny. And if also in terms of what Judge Callen did review and did not review, he does make a comment in the context of Stafford's motion for reconsideration. I think this is fairly important, that he said, he writes, denied, I have reviewed all the filings, everything that's been submitted in this case. I do believe, I think there's no question that Judge Callen looked at this case and was probably a little, he was probably
dismayed.
Thank you, Your Honor. Dismayed with both sides. We had asked for attorney's fees at the beginning. I think it was a couple $1,000s. If this had been resolved, a couple $1,000s.
Yeah, it was like $1,700.
Right. Instead.
So did the fact that Judge Callen said that he looked at all of the papers entitle him to change that word allowed by Judge Buckley to denied?
No, I don't think he was changing the word allowed, Your Honor. I think he was being consistent with Judge Buckley's order because she left it open. There was no determination of attorney's fees. It didn't say, the affidavit shall result in the fees that are part of the affidavit to be entered.
And the court will thereafter decide the amount of fees and costs to be awarded. That's what she said. That's the last line. Sounds to me like she was anticipating an award. And all that was left was the amount.
Your Honor, we obviously disagree with that. We agree with that Judge Callen had the discretion. And again, I think what makes this case difficult for Stafford is the fact that they signed off on the joint proposed order in addition to the two separate orders that gave Judge Callen that ability to make the decision he made.
So I want to make a statement and then ask a question. The statement is to correct something I previously said about the entitlement to fees being statutory on the part of the interpleader plaintiff. It looks like it's not, I couldn't find a statute. It's not even in Rule 22, which is the interpleader rule. From your memo in support of your motion to reconsider at Record Appendix 288, it looks like it's a matter of case law, and I don't even see any reported cases there. It's Superior Court cases. If there is a reported case, maybe you could let us know what it is. that entitles an interpleader plaintiff to attorney's fees.
Thank you, Your Honor.
And then I want to ask you a question.
Of course. No, thank you for pointing that out.
I just wanted to correct what
clarifying.
I had said previously.
I don't recall. I thought there was a statute. Your Honor has now clarified there is not.
Well, I'm quick research on an iPad
Thank
on
you.
the bench, so I could be wrong.
The wonders of technology. What I will say, I've been doing, for what it's worth, I've been doing this a very long time, and I've been involved with foreclosures and interpleaders. And in my experience with interpleaders, it's the standard practice, and I don't have a case I can cite to at this moment, but it's always been the practice that the plaintiff who is filing the interpleader, they are allowed to recover the fees that they've incurred for having to file the interpleader. This is also true not just in the context of foreclosure. I've been involved with other cases in Superior Court where there were fees that were, there was some uncertainty as to how fees should be distributed, and that the plaintiff would file
I suppose the theory is the interpleader plaintiff says, I'm just a stakeholder here. I don't care who gets the rest of the money, but I shouldn't be put to expense to help them figure out their issue. So pay me my fees of filing this interpleader action, depositing the money into the court, and then let me out.
That's exactly the case, Your Honor. That's correct.
So my question is, let's assume Judge Callan had felt bound by Judge Buckley's order and thought that his role was limited to determining the amount of the fee award. It's my reading of that joint motion that U.S. Bank would have had a right to appeal that and challenge the basis for any fees at all. Is there something wrong with that?
No, I don't believe so, no.
Okay, so let's assume that Judge Callan let's assume that we reverse here and send it back on the ground that Judge Callan had no ability to revisit the Judge Buckley's award, saying that there was an entitlement to fees. And we would order Judge Callan to determine the amount. U.S. Bank would still have a right to appeal.
That's my understanding.
And raise the question of entitlement?
Well, if this court remands, I'm assuming, Your Honor, that if you were to remand, you would conclude that there was no ability to address the entitlement. You would be sending it back.
Well, it would only be on my hypothetical is on the basis that Judge Callan should not have revisited it.
Right.
Not that obviously Judge Buckley ruled that the plaintiff was entitled, or the defendant was entitled to fees. You disagreed at the time, and I'm not sure that you waived any right to appeal that. It certainly looks like you were trying to preserve it in paragraph 9 of the joint motion. So I'm just wondering whether the central dispute here isn't the entitlement to fees, not whether Judge Callan was entitled to revisit Judge Buckley's. You don't have to answer that. Your time is. If you have an answer, great. But
I apologize. What's that?
I'm sorry. I said you don't have to answer that.
Thank you. I heard that, and then
yeah. If you have an answer, great. But we're over time, and
yes, I'll rely on my brief. Thank you.
All right. Thank you. Thank you to both counsel. Very interesting case, and thank you to our court officers and our law clerks for assisting at today's session. And with that, we are in recess, or we're adjourned.
We'll stand in recess.